Danny. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting and closely within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now, take the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and I wish you all a happy new year. Welcome to this sitting of the Massachusetts Appeals Court. It is my great privilege today to be sitting with Justices Englander, who is on my right, and D'Angelo, who's on my left, and my name is Gabrielle Wolohojian. For those of you who've appeared before, I'm sorry for the repetition of the basic ground rules, but I will go over a few of those right now. Each side receives 15 minutes to argue. We do not permit rebuttal, so don't try to reserve time for rebuttal because that request will not succeed. The yellow light will go off about a minute and a half before the end of your 15 minutes so that you have a way of husbanding your time, the remaining time, to end your argument the way you'd like. Generally, we try not to pepper you too much during those last minute and a half so you can wrap up your argument in the manner you'd wish. When the red light goes off, your time is over unless the panel has additional questions to ask you. You may construct your argument in any way that you like, but I'd like to tell you that the panel will have read your briefs, the relevant portions of the record, and so you don't need to feel that you have to spend your time educating us on basic facts. And with that, I'm going to call the first case, which is Commonwealth versus FRANCO Joseph, case number 2021 P1170, and who's arguing first?
I am, Your Honor. Michael Warius for the appellant, FRANCO Joseph.
Okay, so...
The signs were backward today.
Backwards? Wow.
I thought maybe there was a new year, a new layout, so...
All right.
It's highly unlikely we've
Welcome to
changed
2023.
There we go.
I had a moment where I just couldn't quite figure it out. All right, we will stretch our imaginations here and accept that the appellant is on that side of the courtroom today. We are ready whenever you are.
Thank you.
Yep.
This case has one singular issue for a new trial, and the question here is whether arguments made by the prosecutor at opening and closing amounted to a substantial risk of a miscarriage of justice. The types of arguments that were made, I think, cover three of the categories of potential improper arguments, that there are facts not in evidence, improper vouching, and appeals to sympathy. The question here at a bench trial is to what extent also the judge could be tainted. The record here is not very clear about the considerations of the judge. He does give a brief message about why he's making the ruling that he's finding the verdict that he's finding. He does acknowledge that there is a credibility contest. This was an assault and battery case that involved two witnesses, the victim and the defense called the defendant himself to testify at trial. So really it was a credibility contest in the truest sense of two witnesses. At opening, the Commonwealth mentioned that the victim did not wish to proceed in the matter, and at closing mentioned that the victim did not want to be present.
So can I ask you about, so let's say that there had been a motion in limine to treat the victim as a hostile witness because she had been, she was reluctant to appear, she was reluctant to testify, or it looked like she was recanting previous testimonies, something along those lines. And the judge heard that motion, and in the context of that motion, the prosecutor made the same kind of comment that the prosecutor here made in the opening, which, by the way, I agree with you, is not the subject matter of an opening statement. It doesn't foreshadow the facts, but just, just says to the judge, can we treat this witness as a hostile witness and therefore, use leading questions, in essence, cross-examine her because she is reluctant to testify, she doesn't want to testify. And then the judge hears that motion, rules however the judge is going to rule, and it's a bench trial. We wouldn't, I don't think, disturb the verdict simply because the judge had heard beforehand that the victim was reluctant to testify, would we?
I think the question really appears in a bench trial is the considerations of the judge. This court had an unpublished decision that I did reference in the Lewis case where the judge made it clear that he was not considering a certain matter that should not be in evidence.
The problem is he wasn't asked to. He wasn't asked to not consider it by anybody. That's the problem, where you're an SRMJ, right?
Exactly. And it really is a fault of the defense counsel in this case because his defense was to present the difference of credibility between the victim and his client and calling his client as his sole witness. There wasn't any other sort of physical evidence. There was no pictures, no medical reports. There was no other witnesses to any injuries. It was simply a contest between these two individuals and whose credibility. The judge here acknowledged the credibility, but didn't acknowledge why, in fact, he was finding the victim to be more credible than Mr. Joseph.
Is he supposed to? In a verdict? Isn't a verdict guilty, not guilty?
Well, if he's going to speak, I think it would be better if he's clear in this instance, especially where the Commonwealth is making these points at opening and at closing about why he's finding the testimony to be.
Can we just get back to Judge Wolohojian's question? I mean, at a bench trial, you have this situation where he's also ruling on evidence. And it would have been perfectly appropriate for the prosecutor to walk up before it started and say, Judge, I got a preliminary issue. The victim doesn't want to be here. Right? That would have been perfectly appropriate. I need you to allow me to lead.
I think under those circumstances, though, it would have alerted defense counsel, possibly, who missed the opening and closing issues. It would have alerted him to ask the judge to place on the record, I believe, that he's clearing his conscience of what he's heard and he's not going to consider it in evidence. I mean, I think here we're dealing, unfortunately, with a situation where defense counsel did not recognize the issues, and that's why we're in substantial risk of a miscarriage of justice. But I think if defense counsel was alerted by such a motion, he would have, I think, made that, or the judge himself would have made this and said, your witness is going to be treated as hostile, and I'm not going to consider the reasons why, but it will be considered that way. But I don't believe that this case presented that issue whatsoever. I mean, I don't believe this was a situation of a hostile witness. I mean, the witness testified dutifully on the stand, answered the questions.
Well, you say that, but we've got the cold record, right? And which is, I think, a real significant issue for me. We don't know what her body language was. We don't know what the prosecutor thought. So, your opponent makes the point, look, the prosecutor may have thought in opening that it was going to become readily apparent that the victim didn't want to testify, and that he needed to alert the judge to that as part of the opening statement. That's done in good faith. If it's done in good faith, it's not an error in the opening, right? Well, and then to further my point about a cold record, it may be that in that courtroom everybody knew that the victim didn't want to testify, and so the statement in closing, didn't want to be here, may well have been an appropriate statement based on what was known in the courtroom. And without an objection, we have no record from which we can evaluate that.
The issue, I think, at hand is the fact that we have to resolve this impropriety or alleged impropriety in the favor of the defendant in this kind of case. I mean, if we don't know, then this
No, I would
should
think
go back.
exactly the opposite. Find me a case, or cite me a case which indicates that where there's no objection, we have to resolve a debate about what happened in the courtroom in favor of the defendant.
if we look at the record of this case and you look at the facts that were available, it was a very triable case. This is not a case where someone went to trial.
Don't
with a
disagree with you
certain
on that,
loss.
counsel.
And I think that any sort of taint that may have happened because of this is an issue. And what troubles me the most is the fact that at a bench trial, most people don't give an opening, I feel like. Or if they give an opening, it's very short, especially in the Commonwealth's end, that this is going to be a case about the victim. She's going to testify to these things that happened, and it's going to make out our case for assault and battery. That's not what happened here. The only statement is that she doesn't want to be there.
I guess I'm missing your point as to why an objection would have made a hill of beans a difference. Let's assume there was an objection and the judge said sustained. Under the case law, repeatedly, judges are presumed to follow the law. So he knows that anything said in opening and closing is not evidence. So no matter what the prosecutor said in opening or closing, the judge, presuming to know the law, is going to focus on what the evidence was. So why does it make a difference?
Well, if the judge knows the law, he would also know that the presumption that a judge correctly instructs himself is gone when the record doesn't support those considerations. So if the judge did believe that this could be an issue, the judge should have on the record indicated so. He should have indicated that his consideration of their credibility doesn't take into account whether or not Ms. Faustine wanted to be there or not wanted to be there.
Can you cite one case in any jurisprudence that suggests that a judge is supposed to make that kind of remark when finding a verdict?
I don't think it's done as a broad rule. I think it's a case-by-case basis. I think the Commonwealth versus Louise case that I referenced, the unpublished decision, this court indicated that this is what the judge did and this is what he should be doing under these circumstances, indicating he's not accepting, improper considerations of things that were not admitted. Here, I think it...
So I have a slightly different question. It seems to me that on appeal, you have the burden to show that there was a substantial risk of a miscarriage of justice from the error. Let's just assume it was an error. And what we've got here is that when the judge announces his verdict, he says that the issue in the case was credibility and that he finds the plaintiff's testimony credible. So, to my mind, in order for you to prevail on your argument, there would have to be something in the record to demonstrate that that credibility ruling was infected by the statement in the opening. The closing, I think, to be frank, at least for me, is a much weaker argument for you because it's just 3 words in the middle of a string of reasons why the prosecutor says that the victim should be credited. So can you tell me what in the record would support your argument that somehow the statements in the opening and closing were the basis for the credibility ruling? Are you just asking us to assume that they must have been? Is there anything to indicate that they were? Because it's your burden on appeal, right? We can agree on that?
Yeah, I do agree, Your Honor. The facts of the case itself, as they did play out, I think relate back to the fact that there was improper consideration, especially as it pertains to feeling sympathetic for her, because her story itself had internal flaw. And the main internal flaw, I believe, in her story is that if she was hit, she goes to work and spends a half day there. She indicates that she indicates before she leaves work, before she leaves the car, that she wants a ride back from home from work after by Mr. Joseph. Now, when she's at work, she indicates that she leaves work halfway through the day because she was having a light sensitivity to her eye, that there was an injury to her eye. There's no photographs of the injury, no medical treatment for that injury. She goes to the police station, Your Honor.
It may have not been the strongest case, but that seems to me a different question than whether there's anything in the record to indicate that the judge took the judge's credibility determination rested on the statement in the opening or closing.
Well, I think that the
Right,
facts
so
of the
there are weaknesses in the victim's testimony, but, you know, the judge did say it was the testimony that he was finding credible.
I mean, going back to the standard for these type of arguments in Miranda, I mean, this is one of the factors, as I've indicated, you know, that plays a part. This was a genuine question of guilt or innocence. It cut to the heart of the case. It was sufficiently significant in the context of the trial. The context of the trial was, who do you believe? Mr. Joseph's testimony is just as believable as hers, if not, I believe, more. But the question...
How do we get there? I mean, it's clear from the verdict, and this is something that we're just going to have to accept on appeal, that the judge did not credit your client's testimony. Because
the judge said he didn't find him to be
if he had
credible.
found it credible, he wouldn't have ruled the way he did. So it's just, he just didn't credit your client. And that, I think, we have to accept on appeal.
The main factor, I think, would have to come down to this idea that there's a possibility of taint, and that judges, and their case law says, judges are not immune from the same type of taints that jurors are immune from. So there needs to be a recognition here. And many cases that come before this court, you'll always see this idea that, oh, the DA was sailing too close to the line of permissibility. And we keep seeing that over and over and over.
Counsel, can I ask you about that?
Yes.
In opening statement, a lawyer has to have a good faith basis to believe the evidence might be admitted. Mm-hmm. Wouldn't you agree that there are some circumstances where on direct examination, the prosecutor could have asked this witness a question, something to the effect of, you don't want to be here? If she had been evasive in her answers to direct examination, wouldn't that have been a fair question of the prosecutor to say, look, stop answering that way, you don't want to be here, isn't that correct? That would have been a proper question, wouldn't it?
I believe if there was a hostility beforehand, as Justice Wolohojian indicated, it probably would have been better for a motion to eliminate than it would have been for a trial.
But how do we know the prosecutor didn't believe that she was going to be somewhat hostile and evasive, and therefore she had a good faith basis to believe, I'm going to ask this witness that question?
I think here, I mean, it would have been something that she would have alerted the judge to in advance if that was the case. And also, I think that there's this aura that perhaps Mr. Joseph now has done something. He's threatened her, intimidated her by saying what the prosecutor did say. I think if the case was a true belief.
You're reading from the opening that she didn't wish to proceed in this matter, that somehow makes it that the defendant threatened her? Couldn't it be she just doesn't want to be there? She doesn't want to testify?
It's possible. I mean, case law does indicate that threats and intimidation may come through as admissible evidence as well. There's no evidence of that in this case. I mean, but I do believe, though, if there was a conflict with the Commonwealth's sole witness in a case that was based solely on the witness's testimony, that would have come up in the record.
Okay, let me see if there are any further questions. Otherwise, we're going to have to leave it there. Thank you very much for your argument.
Good morning, Your Honors. Nathaniel Bodwin for the Commonwealth. Before I get into my argument, I do want to acknowledge that the victim in this case is watching this argument live on the court's YouTube page. In terms of the opening statement, if evidence that's mentioned in an opening statement does not come out during the course of the trial, it should not be presumed that the prosecutor acted in bad faith. And absent a defendant showing that there was bad faith, without that, it's not a grounds for reversal.
How is it that the Commonwealth could introduce what was said in opening here, which is that the victim told the Commonwealth that she didn't wish to proceed in this matter, which, as far as I can tell, would be hearsay?
For reasons that were discussed earlier, perhaps a prosecutor, when meeting with the witness, would have expected there to be certain...
It might have been able to have been conveyed to the judge in the context of a motion in limine, which did not occur here. But how could it come out into evidence? How could that be introduced? How could that hearsay statement be introduced in evidence?
If during the course of the trial, if, specifically in the opening you're asking?
The opening says, "I would just let the court know that she has indicated to the Commonwealth," which I assume was through speech, "that she didn't wish to proceed in this matter." How would that hearsay statement be admissible?
I would agree that perhaps the proper course would have been filing a motion to eliminate, but I believe a prosecutor meeting with the witness, in a district court case, would have probably spoken to her, maybe a few minutes before, may have gotten some indication from that witness that there would have been some hostility.
Sure, but that doesn't mean that the Commonwealth can put everything that's inadmissible that they happen to have done in the lead up to the trial into their opening statement. What can the opening statement contain?
I do understand your point, Your Honor, but again, it's the defendant's burden to show that the prosecutor acted in bad faith, and I think...
Where in the record does it suggest that the prosecutor even asked a single question on her direct examination to lead the court to believe that she didn't want to proceed in this matter?
There is nothing specific in the record, a question that was asked on direct that would indicate that she didn't want to be there.
So
I certainly concede that.
Doesn't that infer that she made this statement in opening, not intending to introduce it at trial?
No, I don't think it does. I think the prosecutor, in this case, had a good faith expectation that that would have been elicited during a direct examination. However, it was not. And again, it's the defendant's burden to show that there was bad faith.
What would be the good faith basis for thinking she's going to be able to elicit inadmissible hearsay testimony?
I guess my answer is still the same, Your Honor, that in preparation for trial, it would have been indicated to her perhaps right before the trial that this could be a witness that would appear reluctant to be there because of her body language or because of her demeanor.
But the witness might have said all sorts of things to the prosecutor before trial, some of which is admissible, some of which isn't admissible. It doesn't mean just because she told the prosecutor something before trial that the prosecutor gets to put it in the opening statement.
I'm not going to argue that certainly the better course of action would have alerted the judge pre-trial to this issue.
That it might be an issue rather than putting it into an opening statement.
Yes.
Okay, so perhaps then we should turn to the question of prejudice.
So in terms of...
There was an exchange where there's an indication, even on a cold record, that there was some concern about the witness's reticence. There's a point at which the prosecutor asks a leading question, there's an objection, the judge says, I'm going to give her some leeway in this regard, which is an indication, isn't it, counsel, that maybe in the courtroom people are aware that there's hesitancy on the part of the witness.
And certainly a transcript or even the audio of this case, of this trial, which I did listen to prior to coming here, you're not going to see body language. You're not going to see someone with their arms folded across their chest or giving an expression indicating to everyone in that courtroom that they're uncomfortable, they don't want to be there, that they're reluctant to testify. In terms of prejudice, those statements, particularly in the closing argument, the context in which it was stated was about the demeanor of the witness, which cases say is proper for any attorney to bring up in closing argument because that goes to a credibility determination. So I think that's proper. I don't believe, as the defendant suggests, this was improper vouching. In fact, what happened here was the exact opposite of what happened in the cases cited by the defendant. In those cases, the prosecutor essentially was saying, look, this witness was willing to come in, testify about these embarrassing details. They had no motive to lie. What you actually had here was the exact opposite. The prosecutor is saying she's unwilling. She was unwilling or reluctant to come in. So I don't believe this is a case of improper vouching, which means that this comment was not an error. It also wasn't a case of an improper appeal to sympathy. When courts have found that to be the case, the comments by the prosecutor are usually pretty egregious, and they usually fall into one of two categories. Either it's the prosecutor repeating very sympathetic traits of a victim, or the prosecutor actually encouraging juries to be angry with the defense. And even in the cases cited by the defendant, the Santiago case in particular, that was a case where it was a homicide of a young pregnant woman, and the prosecutor was repeatedly emphasizing her young age, her pregnant status, which wasn't, didn't have anything
Yeah, but why,
to do.
I mean, the problem with that is why does the prosecutor reference didn't want to be here in closing? The prosecutor's making a point that they think is helpful to them with the judge regarding finding her credible, right? Didn't want to be here, was here anyway, she's just testifying to what's the truth, right? That's what the prosecutor's trying to get across.
I think at that point, the prosecutor is under the impression that she perhaps elicited that testimony, that she expected to do so. It was stated in the context of demeanor. Look, this victim was calm.
My point is, you're on an argument, we're talking about prejudice, and you're on an argument that a person's not prejudiced by this. This is the opposite of what usually is considered to be prejudicial prosecutorial argument. And my point is simply, the prosecutor made this argument for a reason. They made this argument, didn't want to be here, because they thought it was helpful to the prosecution in arguing the credibility of their witness.
Well, I think the original question was prejudice, so let me go into why this is not a substantial risk of a miscarriage of justice. And because, again, so courts look at 4 factors when an error is alleged in a closing argument. First, they look to whether there is an objection. Obviously, there was no objection in this case. The second issue would be whether the comments were limited to a collateral issue or whether it went to the heart of the case. The question of whether a victim was willing or unwilling or reluctant to testify does not go to the heart of the case. It's a collateral issue.
Really, the only issue in the case was the credibility of the witnesses.
But I would suggest that the few words in the closing that she didn't want to be here did nothing to diminish the victim's testimony that this defendant committed an assault and battery on her when she was pregnant.
No, but what Justice Englander is suggesting is that they are an invitation to the judge to make a credibility determination in favor of the victim, given something that the prosecutor apparently seems to think might make a difference, which is that the victim was unwilling to testify. And therefore, in that sense, it goes to the core issue, which is what the judge understood the core issue to be in the case, which was the credibility of the witnesses.
Certainly, and this is a case where there are only 2 witnesses. There was obviously going to be one person's versions of events and another person's version of events. But I don't think simply stating that the victim may have been reluctant to be there, especially at a bench trial where, well, I don't want to go there, but I don't think that those few words diminished in any way the actual testimony of the victim as to what happened, and also what the defendant said, and the judge also was able to evaluate his demeanor, his body language, and as he stated in open court, he found the victim to be credible, and inferred that can be inferred that he didn't find the defendant to be credible. And I don't think these few words in an opening would have caused this judge to completely be swept away by emotion and forget what the testimony was, and forget what the victim said versus what the defendant said. And again, it didn't diminish what the victim actually stated. And if there are no further questions,
I don't see any.
That's on my brief.
Thank you very much.
Thank you very much.
Both for your arguments. The case is submitted. The next case is Commonwealth versus Javier Rosales, 2022 P0125.
And I take it we're back to the appellant is going to be over here.
Morning, Your Honors. May it please the panel.
Just wait. Okay, good. Everyone's settled in.
May it please the panel. My name is Russ Fuller, and I'm representing Javier Rosales in his appeal before the court today. In this case, the primary issue is essentially the prosecutor planned and executed a trial by ambush in this case. the prosecutor learned of highly prejudicial evidence just prior to the trial. We're not sure exactly when, because there's some back and forth between the court and the prosecutor in terms of when did she learn of this evidence. At one point,
Did you try the case?
Pardon me?
Did you try the case?
I did not, Your Honor.
Okay.
At one point, she said the officer reported to her, I'll actually quote, confirmed with me today, the day of trial, that he had seen injuries on the victim.
What's the case that you rely on for the obligation that this had to be disclosed in discovery? Rule?
That's Commonwealth v. Gilbert primarily is a case that.
So let's start with a rule. Is there a rule that says this has to be disclosed during discovery? It's inculpatory. Is it exculpatory?
It's not exculpatory, it's inculpatory, but the effect of it is to take in this case, is to take a trial that's a very triable case.
But it's not reduced to writing,
Right.
right? Does Rule 14 deal with statements that are not reduced to writing?
Your Honor, I believe that the Rule 14 does specify writing. The court in Gilbert noted that in that case, the evidence was also not reduced to writing by the prosecutor. And the court noted that.
And the concern in Gilbert was that what had been learned by the prosecutor subsequently was inconsistent with what had been disclosed in writing. Isn't that as I read Gilbert, that's sort of the fundamental concern, right?
Yes, Your Honor, I agree.
Okay.
Isn't this officer's testimony inconsistent with the other officer's testimony and thereby making it exculpatory evidence? If one witness says A, and the prosecutor knows about it, and the prosecutor knows that witness B is going to say something different, that's inconsistent statements. Isn't that exculpatory evidence?
I can see your point, Your Honor. I think that you could argue, on the other hand, that it was inculpatory because it created much more of a possibility, it created much less of a possibility that a juror would have a reasonable doubt in a he said, she said assault and battery case where the victim had no injuries, that the investigating officer had noted no injuries, had said that if he had, he would have taken photographs. The prosecutor brings in the interpreter, who's also a police officer, and presents evidence that the victim had injuries. The defense attorney went to court that day thinking the case was one thing, and it turned out to be an entirely different.
Sure, but I mean, I think correct me if I have any of these facts wrong. The prosecutor tells the judge, and there is nothing to contradict this in this record, that the first she learned of the interpreter's observation was the night before it came out at trial, correct?
Yes,
so we're going to have to accept that, I think,
Yes,
here, because
yes.
there's nothing to contradict that. So to the extent that there was an obligation, it couldn't have sprung into being until the prosecutor learned the information herself, correct?
Yes, Your Honor.
All right. So we're talking about, when we're going to measure prejudice, we're talking about the measure of prejudice between non-disclosure, if there was an obligation to disclose, the night before versus the time it does come out. And the judge, when all of this comes up, gives defense counsel not only an opportunity to consider what they want to do, but also then solicits their view as to what the appropriate remedy might be at this point. And the defense counsel doesn't ask for anything. Basically, it's agreed that the prosecutor will not ask anything more. The examination of the witness abruptly then ends, and it's after that point that that trial counsel then consults with the defendant to determine whether or not, right, if I have this right, that the defendant is going to testify. So what I'm trying to figure out is, assume there was an error in not disclosing the night before, the day before. What prejudice resulted from the, let's call it one day, but I don't know if it's 24 hours or 18, I don't know what the number of hours is, delay. What would have happened differently, in your view?
Well, I think that the importance of the delay, the significance of it, was that the defense attorney was, in fact, surprised at trial. The defense, there's no evidence that, there's no information that the defense attorney would have known this information.
But to follow up Justice Wolohojian's question, let's assume it was ambush. I'm going to concede that for the sake of this question. What would the lawyer have done differently if he had learned about it the day before?
I would submit, Your Honor, that in the middle of a jury trial, when evidence like this comes out in front of a jury, that a defense attorney is only human, that it would be fair to infer that, and based on the conduct of the trial by the defense attorney after that revelation, I do think that she was surprised. And the surprise itself was the prejudice, that it was improper, and that the prosecutor had to know that this was going to surprise the defense attorney. Well,
but the surprise itself as the prejudice doesn't get you where you need to get. You need to have an impact on how the defense was presented. I mean, the case law on that is clear. Okay, it's not. The prejudice is not the evidence came in. The prejudice is you would have done something differently and that it had a material impact on the defense. And Judge Wolohojian points out, judge took a 10-minute recess. He was troubled by this. And they come back, and defense counsel doesn't say, mistrial. Doesn't say, Judge, I want a deposition. Judge, I want to know exactly what this witness said to the prosecutor at exactly this time. He says none of those things, right? So the judge isn't presented with any request for any of those things at that point.
I do think I would disagree.
Where is the indication from what defense counsel did, having 10 minutes to think about it, that I feel like I'm so badly prejudiced that this trial has gone off the rails?
Well, I do think it's disagreeing slightly with the premise that she did not ask for the court to do anything. She did ask for a ruling on her objection. She objected to the evidence, and when asked by the judge, she requested a ruling. Now, in hindsight, and you know, from our vantage point today, could she have done other things? Requested a continuance, asked for a mistrial, certainly. But I think that's part of she was affected by an unfair conduct of the prosecutor, and that the prejudice is really
unfair if you accept the notion that this case fits within Gilbert, right?
Yes.
Because it's not, as I read the rule, and I'm trying to figure it out, okay? I didn't do what you guys do every day. But it looks to me like the rule is about things that are reduced to writing. You don't have an obligation with respect to a witness who doesn't have a report in front of you to write out, you know, this is what this witness is going to say and hand it over to the defense, unless it's exculpatory.
Mm-hmm.
And are you familiar? Well, I'm going to ask your brother about a case called Commonwealth against Rodriguez Nieves, which came down from the SJC about a year ago. But anyway, there's no question there, so you can keep talking.
Okay. Thank you, Your Honor. Well, again, I will come back. I think that the nature of the trial changed fundamentally. There was.
In which way? I mean, that's what I'm trying to get at. If I read the transcript correctly, early on, and maybe I'm getting the facts mixed up with the previous case, but did the judge not inquire? Well, I don't remember. When did at the beginning of the trial, I believe, unless I'm confusing this with the last case, in which case I apologize, the judge asked whether there was an exchange with defense counsel as to whether the defendant was going to testify. And the lawyer said, we're not sure yet, maybe, maybe not, I'll let you know. Then the topic came up again after this testimony by the interpreter officer. And and there was a consultation between counsel and the defendant, and it was then that it appears that the decision was made for the defendant to testify. Am I correct on that chronology?
Your Honor, honestly, I don't recall that part of the transcript.
Well, then I must be getting it confused with the other case, in which case I apologize.
It could be that you are not, though, because I was not necessarily focused on that particular.
Well, so the reason why I focused on what happened is because I'm trying to get a handle on what decision-making may have been affected by, and let's call it the late disclosure, just assuming it was a late disclosure. And the only thing that I can see that might have happened was a decision about whether to have the defendant to testify. I couldn't see anything else that might have been affected. So that's why I'm really trying to focus on what is it that you say was affected by the timing of the disclosure?
Well, for one thing, Your Honor, the fact that it occurred, the disclosure, I guess I would argue that there was no disclosure per se, that the evidence was just introduced in front of the jury.
Sure, so let's just call that a disclosure.
Yes, Your Honor. So I'm sorry, I'm falling back on what I would argue is the impact of that, but that may not be responsive.
Well, you know, lots of surprising testimony comes up during trials. Lots of surprising testimony. The fact that you're surprised by the testimony or that the testimony is not favorable to your side doesn't usually merit reversal, because surprise and is just not a grounds for reversal unless there was something improper in the surprise or some kind of special prejudice, I think, from the surprise. So what I'm trying to find out is what other than surprise is the problem here?
It's the conduct of the prosecutor herself in this case. In other words, not only not disclosing the evidence, but nevertheless using the evidence, important evidence that shifted the trial, I contend, and that was before the judge. The judge did understand that the prosecutor had not disclosed the evidence to the defendant and then had used it. And then there was an eruption in the court, objection, the interaction with the judge. And so I think this is analogous to Gilbert, the case Commonwealth v. Gilbert. The judge, I contend, erred when he decided that this event, this improper conduct, and the effect of the evidence coming out in front of the jury was okay. We could just move on with the trial.
But is there a waiver here? Because there's an objection, proper objection, I would suggest, and then the prosecutor is actually the one that makes the offer. If you want to strike it, that's fine. And the defense lawyer doesn't say anything. So the argument that the evidence came in improperly, the prosecutor may be accepting that and say, okay, I get it, strike it from the record. Isn't that what the appropriate response should have been from the judge there?
Yes, I agree.
So if the prosecutor suggests it and the defense lawyer doesn't respond, I agree with that, and in fact the judge asks, what do you think we should do? Isn't that a waiver?
I think it could be, as stated, Your Honor, but I believe that the transcript doesn't, that there's a little bit of a leap there to get to that. I think the attorney, my reading was silent, and that the prosecutor offered to.
No, I don't think so. I think the prosecutor says on page 74, if you would prefer that to be stricken from the record, that's fine.
I agree
then
with
the
that.
prosecutor says we learned of it, the court says we learned of it today, etc. Defense counsel, I'm sorry, this is mainlined. And then the judge says, why don't we take a recess? So the judge gives the defense lawyer an opportunity to think about it, to think about what the prosecutor just suggested, and then they come back on the record, and the defense lawyer doesn't say, I agree with striking it from the record. Doesn't say anything. So why shouldn't we say it's waived?
My reading of the transcript, Your Honor, is that the prosecutor offers that. I agree to that. If the court wants to strike the evidence, strikes, that's okay. And the judge, when I read the transcript, the next thing I see is the judge responding, saying, kind of going back and forth and saying, no, I'm going to allow it if the Commonwealth is going to move on. I don't think waiver is, at least I didn't see that in reading the transcript, and I appreciate the point.
All right, let me see if there are any other questions. No. With that, your time's up, so thank you for your argument.
Thank you, Your Honors.
Attorney Sadlin?
Good morning. My name is Patrick Sadlon, arguing on behalf of the Commonwealth. There are three issues, though, in my opinion, really one main one, which is one, that the trial judge correctly ruled and did not abuse his discretion at the evidentiary hearing, that nothing improper was done by the Commonwealth or the police witness about the new evidence put at trial.
So you don't think it was improper that the prosecutor didn't disclose this evidence prior to trial?
Well, I guess I'll preface it by saying, you know, there's the prejudice issue, then there's also that the abuse of discretion by the judge. So it had to be that.
Well, you just said it wasn't improper. Let's focus
right.
on that.
Well, to get there, I'm just saying deference to the trial judge is, you know, what we're looking at, and he says.
Okay, can we stop though, counsel? I want to focus on the question that Judge D'Angelo asked.
Sure.
Was it improper not to disclose it the night before?
I said that because the judge says, and I agree with the judge when he says, I glean no hint from the witness, this was on page 76 of the transcript, that the Commonwealth did anything improper, nothing improper was done. I think it would have been ideal if the Commonwealth had notified the defendant of this evidence last night, but the discovery rules don't necessarily parallel what's ideal.
Okay, so what about Gilbert? So as I take it then, the Commonwealth's position is this is just a statement of a witness, it's not reduced to writing, and therefore the discovery rules do not require that it be produced. The witness needs to be made available so that defense counsel can go talk to them, right?
Right.
Okay, I understand that position, but what about Gilbert?
In my opinion, I agree about that. You know, it wasn't written, there's nothing in the discovery obligations to obligate them to share that, but I'd also say that Gilbert is not.
Let me back up there for a second.
Oh, okay.
I'm not sure I agree with you on that. So just because it's not in writing, if a prosecutor learns that one witness is going to say something that's inconsistent with not only another witness's testimony, but what a witness has written in a report, that's not exculpatory and it has to be disclosed?
It is. I was just meaning that.
Isn't that what happened here?
It is what happened here, but I also want to point out to the facts and circumstances. It was last night. I mean, it's not clear from the record exactly how many hours it was.
The timing to me is irrelevant.
Okay,
If
gotcha.
it happened 1 hour before the trial, if it happened 5 minutes before the trial, or 24 hours, as soon as that prosecutor learned that that evidence was exculpatory, which you just conceded it's exculpatory,
right,
you would agree there's an obligation of the prosecutor to turn it over to defense counsel.
I would agree.
And in this case, doesn't it make it even more so where the prosecutor knows that the defense strategy is there's no injuries? He says it in the opening statement.
He doesn't.
Comments about it in direct test, in one of the cross-examinations of officer number 1, makes a point of that, goes through a questioning about that, and then the prosecutor puts on someone who she listed as a rebuttal witness. So she's using it to her benefit.
I would agree, and again, I would also, you know, agree with that and the sentiment of the trial judge who said it's not ideal.
Why isn't it bad faith? Because you made a point of saying, I agree with the judge where he says it's not bad faith. So now we've just gone through, it was exculpatory, she used it to her benefit, and she knew what the defense's strategy would be, and this was undercutting it.
Yeah, and I would just add one more thing, that from what the prosecutor said, she knew that this was a change in this witness's testimony too, because she had met with the witness before, and the witness had not said anything about the injuries, and then the witness suddenly tells something about these injuries the night before trial.
I would say that, you know, it's not, you know, it's clear the court considered the lack of disclosure the night before and made a decision that it was not in bad faith. The prosecutor, as Justice D'Angelo mentioned earlier, offered to strike the testimony. The defense didn't say anything. The judge even asked the defense counsel, what do you think?
Counsel, I'm sorry, I'm going to go back to it. I asked
Sure.
earlier. Why isn't it bad faith? I know that's what the judge found. We're not bound by that necessarily. What would be more bad faith than this? That she had learned about it 3 months earlier and didn't disclose it? Why isn't this bad faith?
I would say you have to look at it in the circumstances. I think it would be a very different scenario if it's, was it improper in the sense that should the prosecutor have said the moment they learned it, you know, hey, this is information I learned? Of course. But this wasn't 3 months ago that they learned about it. There were limiting instructions. There were other avenues to resolve this issue. Defense counsel could have said, oh, there could have been a deposition. They could have agreed with the prosecutor who offered to strike the testimony. I think it was very clear from all parties involved that this wasn't ideal. The judge handled it intelligently. You know, they make the observation about, he makes the ruling about anything improper, and then after cross-examination makes a second ruling after the 10-minute recess. You know, I had some rationale considering all the circumstances, the nature of the disclosure, which I don't believe was intentional in any way. And it goes on further. You know, this judge clearly made.
Can we go back to something that I think is kind of fundamental?
Sure.
And I did hear you say that you thought it was exculpatory, and I heard Judge D'Angelo ask you that question more than once. But why is it exculpatory? It's completely inculpatory.
I think generally speaking, this is information that they learned of that, you know, the defense counsel should have been.
But how does it, I mean, exculpatory to me means that it's something that could be used in a material way to indicate that the defendant is not guilty. This is evidence that someone observed bruises on the victim consistent with the prosecution's case. Now, are you familiar with the Rodriguez-Nieves case?
I don't believe so.
Okay, well, Rodriguez-Nieves is a decision from the SJC that addresses exactly this issue in a slightly different context. And the slightly different context is that a witness became more inculpatory, but a prior statement of that witness had previously been given that was less inculpatory. And the court in that context said it's an inculpatory addition, but it's also exculpatory because it shows that the witness previously had made a statement that was different. This case, it's not the same witness. It's a different witness who made a statement that's inconsistent. And so my question for you was going to be, is this controlled by Nieves?
I mean, I'm sorry to ask to make a statement to your question, but I believe the evidence in this case, and correct me if I'm wrong, was that the prosecutor had spoken with the interpreter officer sometime in the past, and the interpreter officer had not told the prosecutor on that occasion that he had observed bruising.
That's correct.
It was then later, the day before trial, that the interpreter officer said something about observing bruising. That was the first time that the prosecutor learned of that testimony, correct?
Yeah, that's correct.
And that was inconsistent with the interpreter officer's previous statement to the prosecutor, but also inconsistent with the investigating officer's testimony and report that he had not observed any bruising.
That's correct.
Right. Okay.
I'm sorry, where was there evidence that there had been a previous statement to the prosecutor that was inconsistent with the statement that was made at trial?
I think it's on page 75 and 76. We'll straighten that out on our
Okay,
own. You can
gotcha.
continue where you'd like.
Gotcha.
I'm sort of curious as well about the closing argument.
Sure. I would say, well, one was objected to, one wasn't, so there are different standards of review for each of those. I would first like to point out that at least in the defendant's brief, that they misquoted the comment that I think they said that the prosecutor had said that the entire defense theory is a distraction or something along those lines.
Well, it said the photographs are a distraction.
Right, that was, I think, what was the actual quote.
I'm having a hard time understanding what the prosecutor meant by that sentence.
I think what they meant, because
the photographs were evidence, so they're not really a distraction, right?
I think what they meant and what they're trying to allude to is that, this is it was a close case, it was a he said, she said case, and the defendant was the one that had a lot of documented physical injuries. So I think, one of the theories is that, it was a self-defense, even though they didn't request self-defense instructions. But, I think he was just trying to say that actually, that might be, convincing evidence, but that jives with what Ms. Canby had testified to, was that, she was pinned up against the door and pushed him away. That may have resulted in injuries, and then came to the police station. So I think that's all that he meant by that statement. And again, the remarks are viewed in the context of the whole case. Of course, they can't misstate evidence, or refer to facts that aren't in evidence, but in this case, this is aligned with what was presented at trial.
Prosecutor says twice during her closing argument words to the effect of she has nothing to gain from being here. Is that appropriate?
That I would say that's not appropriate, but it's also, it's unclear what he means by that.
She's arguing credibility of the witness. She has nothing to gain from being here. She says it twice. It's not right, I think. I think we have case law that says explicitly it's not right. So I don't think your prosecutor should be saying that. It's not raised.
Yeah, it's not raised. They didn't object to it, so it would be on a substantial miscarriage of justice standard. So again, I don't think, this is a...
But you have a prosecutor who made the decision not to produce this evidence, as Judge D'Angelo has pointed out.
Sure.
And then you have a prosecutor who, and what's clearly a case about credibility, where the person charged has far more injuries than the victim does. In fact, the only evidence before they got to the trial court, before they started the trial, was that the victim had no injuries whatsoever. That was the disclosure that was made by the Commonwealth. And then the Commonwealth comes in, it turns out that they've got a witness who says, oh, there were injuries, and then they start arguing and closing, hey, she has nothing to gain from being here.
Yeah.
It starts to not feel so good. Part of our job is to decide whether, in fact, we've got something where justice was or was not done.
I agree, but again, those all may be true, but the prosecutor was also the one to offer to strike from it entirely, and the judge made two separate statements, considerations, one before the cross-examination, one after. Defense counsel, while it's unfortunate that they were surprised, that alone does not equate to prejudice.
Our cases repeatedly talk about, especially in criminal cases, that trials are not supposed to be trials by ambush.
That's
to
correct.
follow up what Judge Englander just said, it's starting to sound like that's what this was. The prosecutor is listening to the defense strategy, knows what the defense strategy is, and then wham, right in the middle of the trial, calls a witness that's going to blow that defense out of the water. And she knows about it, and she doesn't disclose it. So isn't that a substantial risk of a miscarriage of justice when it's this trial by ambush that clearly affected the verdict?
No, not at all. I know in Commonwealth v. Edwards, which came down from the SJC, was similar in the conceptual ambush issue, and that was when there was a protective order and they had given the wrong certificate of service. And that was, and I wrote an amicus in that case for the SJC. And talking about, that was a critical moment where, the whole case is on, you have to prove the certificate of service to prove the case. That's one of the elements. And that ended up, that was a main issue in the case. In this case, this is not, well, I'm not going to say this is unimportant evidence, new evidence. It's not the linchpin of the case. I mean, you have the photo.
I don't think it's the linchpin of the case. I mean, I have to say that's certainly not my instinct.
I would respectfully disagree with you, Justice. I mean, there's direct photographic evidence.
The direct photographic evidence is that someone else was assaulted. The direct photographic evidence is the defendant was assaulted. He has marks all over his body.
Right.
The prosecution decides that he was the aggressor, but there's no evidence that's given to the defendant before the trial that there's any marks whatsoever on the victim. And then, boom, in the middle of trial, oh yeah, I saw bruises on her arms. Happens to be entirely consistent with her testimony. First time it's ever heard. You don't think that's important?
Again, I'm saying I don't think I'm not saying it's unimportant. I'm saying it's not the linchpin of the case. I mean, this is a he said, she said, and the jury made the decision, they determined the credibility that...
I know it's the red light, but it's no longer a he said, she said. And that's what makes the evidence so impactful. It now corroborates the victim's testimony. So it takes it away from this is the victim, this is the defendant, they have opposite views. It now puts an independent witness in the corner of the victim. And you don't find that to be the linchpin?
All right, I think we're going to leave it there. Thank you for your argument. It's an interesting case. We have been aided by your both sides' briefing and arguments, and the case is now submitted.
Thank you both.
Thank you.
All right, the next case is 2022P0206, Eric ZUTRAU versus Nicholas ZUTRAU. And I apologize if I've mispronounced the last names. Or the first names. Attorney Larkosh? Larkosh. We're ready whenever you are.
Thank you. Good morning, Honorable Justices.
Good morning.
My name is Dan Larkosh, and I represent the appellant, Eric ZUTRAU, also the appellee on the cross appeal filed by Nicholas ZUTRAU. The primary basis of our appeal are the statute MGL 241, sections 1 through 37, which deals with petitions to partition, and also the Mass Code of Civil Procedure 12B9, which deals with prior pending actions. I think the seminal mistake that may explain some of the inconsistencies in the judge's decision is the fact that the court found that the parties purchased the property together and that they purchased it as a fully constructed home. In fact,
I don't remember the court finding that, but I think everyone here knows that the facts are that the property came to your client from his mother, and that your client then transferred a half interest in return for her promise to give money, which she gave. So why don't we just move on, because that's not a seminal fault in this.
Okay, the only reason I was raising it, Your Honor, is because in the decision it says that the property was acquired as a single-family home, and essentially the issue with applying, collaterally applying the bankruptcy court decision was that the bankruptcy court never dealt with the issue of findings of any kind of misrepresentation or any kind of...
Why is misrepresentation even important? I have to say, I read your brief, I read it very carefully, I read a lot of stuff, and it seems to me that it is uncontested by everyone that your client received money from your opponent's client, right?
Correct.
And didn't pay it back. and that there was a note that said, if you don't pay it back and I make demand, you have to transfer the property to me. Isn't that all agreed?
No, I don't think.
I read the note. What, am I misreading the note?
Well, first of all, the note is the subject of a prior action.
That I think we can all disagree on. Let's just leave that alone. I think I'm not sure that it matters whether it's prior action.
With all due respect, Your Honor, it is contained in, if the court looks at the
I've read it as
Superior Court
carefully
action.
as I can. Your opponent made a very, very detailed description of how it was that it's clear from that complaint that they were not asking for Note A. And you never responded to that. What's your response to it? He says, look, all that it asked for was $100 and something thousand. The note was for $241,000. Couldn't be clearer that that 2009 complaint was not about Note A. What's your response to that?
It's clearly about Note A. The court looks at
Someone says,
at the
if someone says, I'm sorry, in a complaint, they say, I'm asking for the following relief, $80,000 for this, $50,000 for that, and Note A is for $241,000. I think a pretty good lawyer could say, you know what, that complaint is not about Note A. What do you say to that?
The paragraphs in the record appendix are at 313 and 314. Paragraphs 13 through 15, the Superior Court action clearly deals with the promissory note A, and it's listed on the docket as a pending case.
All right, let's just.
2009.
Why don't, assume for the moment, and I understand this is not your argument, just assume for the moment that the prior pending action argument fails. What then, in terms of the arguments with respect to the partition action?
Yes, well then we feel that the court misapplied the bankruptcy court proceedings and findings, because in fact, as I was alluding to earlier, there was no finding by the bankruptcy court that my client, Mr. Eric ZUTRAU, committed any kind of misrepresentation when he initially deeded half of the property to Lalani.
But why would that make any difference? Like, so what if the fraud came later? And in some ways, what difference does it even make? Let's assume there was no fraud, but that the facts were, as Justice Englander laid them out, that your client agreed to transfer in the event of a default on the note, the half equity interest to his half, because the half had already been conveyed to the sister, but then upon default, his half would also be conveyed. Then what problem is there with the judge ruling on the partition petition that your client's equity in the property should go to his nephew?
I don't think that the language of the promissory note itself provides for a forfeiture of my client's equity. What it does say is that
No, and it wouldn't need to, because the equity's now, that's why you're in partition, because that's where the equity is going to be transferred. But it certainly, it may not on its own have transferred the equity, but it certainly indicates that that's the remedy that the obligor on the note has committed himself to.
I think what the promissory note also says is the promissory uses the word if, and says if my client deeds the property, it will wipe out the debt.
Okay,
but it doesn't say what happens to my client's equity in the home. It doesn't dispose of my client's claim to his equity in the home.
All right, but that's, I mean, you in essence put that at play by coming to the probate and family court with a petition for partition.
Before Judge Wolohojian goes forward with that thought, which is important, can we just stop on your representation as to what the note says? If borrower is unable to make full payment to satisfy this promissory note, borrower agrees to sign over all right, title, and interest of borrower's share of the property.
Yes.
That is an agreement to sign over the entire equity.
It's an agreement to execute a deed, Your Honor, but it's not an agreement to convey the equity of, that my client has in the home.
Of course it
What
is.
language could possibly have not been included in that the whole thing was going to be going over?
Well, in the next part of the paragraph, it says, if he does that, it will wipe out the debt. But it is in the nature of a
But
security
he didn't
interest.
do that. I mean, I agree that that's also important,
Right.
but he didn't. Demand was made, I think it's undisputed. Demand was made sometime in 2009, roughly. Never
Actually,
transferred, right?
I don't believe so. I think what happened was there was a foreclosure that was made, and there was no request. I don't recall.
You know, it's in
I
the,
recall there
again,
was a-
counsel, one of the things that's really important is that we know that we're getting a straight shot from what's coming from both sides. It is represented in the briefs without disagreement that there was a demand made.
by a lawyer later.
I believe the year is either 2009 or 2010. I'll go look for it. But are you now representing to us that no demand was ever made?
I'm not saying that. I'm saying that at the time that Leilani ZUTRAU did not make the demand, that it was made later by a lawyer after I believe there was a foreclosure that was.
What I remember reading in the briefs, and unfortunately I don't have the time to go to it, this is a very complicated fact, is that the demand was made on your client before foreclosure was instituted.
For purposes of the argument, Your Honor, I certainly do not dispute that demand was made by Mr. Goldsmith's partner at law.
All right, so we don't want to get down too many rabbit holes here because there are actually a lot of questions, I think, to ask. I take it that we're just going to understand your argument is that whatever the legal meaning or consequences of the note were, they may have transferred some rights and interest in the property, but they didn't, in your view, transfer an equity interest in the property.
My argument would be they transferred no, yes, they've transferred
All right.
no equity in the property.
All right. I actually want to take you in a direction that may come as a little bit of a surprise to you. And for these purposes, I'm just going to ask you to accept, but not concede, that that it was appropriate for the judge, as the case was presented to the judge, to rule that the equity interest, your client's equity interest, should be transferred to the sister's estate. Okay, I'm just going to ask you to accept that. I understand a second part of your argument to be that the judge, even if that part was correct, the judge needed to assess I'll just call it the math involved in that. What, for example, is the fair market value of the property? How does that relate to each person's financial contributions to the property, et cetera, et cetera? Am I correct that you're making that alternate argument?
Yes.
Okay. Then here's something that you may not be able to answer this standing here right now. But here's what's concerning to me about that argument, because I don't like for a result that might obtain here, for someone to obtain a result here that is actually contrary to maybe the interest that they have. So let's assume we accept that the judge needed to do some kind of mathematical evaluation of various factors. That would mean that we would remand for that purpose only. In other words, we would affirm the transfer of the equity interest, but we would say to the judge, you need to do the math. Here's what I'm sort of thinking. In your complaint, you give what I take must have been some assessment of fair market value of $900,000 for the property. It looks to me like basis has got to be at least $500,000, because there's the finding by the bankruptcy court that by a particular date, September, I think, 2006, the sister had paid for more than half of her interest, and that was $241,000, so I'm just rounding that up to $500,000 because I can't do math. So that would leave a possible gain of $400,000. That would be $200,000 on each side. And off the top of my head, I can easily think of more than $200,000 that would be credited to the other side against your half, including things that I don't know, like who's been paying the real estate taxes, who's been paying the water bills, the costs of litigating that they've had to incur to protect their interest. And so my question to you is, do you really want a remand? Because it could end up, the math in that could be really unfavorable.
Well, we would want justice, and I do think that a remand would be appropriate, given that
Only if the numbers came out and you didn't owe the other side any money.
we believe that the numbers will come out, that my client has some equity when the debts
Well, he won't have equity. He'll just have
a dollar amount.
some dollar amount.
Correct.
All right, well, what I would say is, why don't you think about that for a few days? And if your position changes, you can submit a letter to the court just saying, you know, we'd prefer not to have a remand if you reach that question, or something like that, okay?
Yes, Your Honor.
You
Well,
see-
I'll
you
consider
see
that
what
with
you-
my
You
client.
see where I'm coming from?
Yes, I do.
Okay.
That it basically could be more, that he could,
Exactly, like,
Wind
does
up.
he really, you know, you could win here, and it could be, as a practical matter, not a win.
yes, it could be on remand, it could be not.
He
a-
owes the other side money.
Yes. I would just like to also address, if I may briefly, the argument about attorney fees and the request for attorney fees. And we are dealing with a promissory note that it was a 2006, I believe, promissory note. And the judge got this right. The judge said that there was a remedy at law. And first of all, the judge also never did the calculations with respect to whether or not the statute of limitations would apply to the promissory note. But there is a legal remedy, and that legal remedy is to sue an action on the promissory note, which is a prior pending.
But why, okay, so leaving aside, I understand your statute of limitations point, which has not ever been resolved.
Yes.
But there's something called an equity action. Don't worry about the red light, if we could, because this is complicated. There's an equity action, and it's appropriate as an equity action to say, I would like specific performance of the note. That's an action in equity. The note required that the property be transferred. I'd like specific performance of that. The judge's response to that is, that's moot because I've transferred the property pursuant to the partition proceeding. But if, in fact, they were entitled to relief in the equity action as well, can't they get the attorney's fees associated with pursuing a proper equity action for specific performance?
Well, with respect to attorney fees for such things as, there was no egregious conduct. All
No,
we
no,
did was
just
file
under the
a petition
language of the
partition.
note.
There was this issue hanging out. The
Under the language of the note,
right.
they are entitled to fees, right?
Yes.
If they
That's
pursue,
a legal remedy.
well, it doesn't say that, actually, and your opponent's going to have to dance a little bit when he actually looks at the language of the note. The language of the note is an action to collect.
Yes, and there is.
If you're successful in an action to collect on this note, then you get your fees.
Yes,
Would
was.
the equity action, had the equity action been successful in specific performance, have been an action to collect on the note?
Well, it would be a legal remedy to give fees on a promissory note, and we...
I'm not sure I agree with that, counsel, and that's what I'm really trying to understand. Why do you say, maybe the better question is, why do you say that? I mean...
The judge found that. The judge found that, and we agree.
Well, but it's a question of law, so I'm asking you to help me with the law.
Sure.
You know, he files an equity action for specific performance. If specific performance is an action on the note, it's an equity action on the note. And couldn't he get fees for that?
I guess conceivably, a judge could award him fees, but...
Well, actually...
It's a 2006 promissory note, and there would be a defense then, I think, of laches, and I think there should be at least some acknowledgement or analysis in the court's decision as to whether or not why...
Well, you know, you've raised the defense of statute of limitations, and I agree that that defense would have to be addressed. I agree.
Yes.
Part of the reason it's so late, of course, is because there was a 5-year-long bankruptcy proceeding, which stayed all proceedings, right?
There was that, and there was also the fact that Nicholas ZUTRAU filed numerous frivolous actions in the Superior Court. Some were dismissed, and also requests for consolidation, which my client had to respond to. Again, they were all dismissed instead of pursuing the foreclosure, which back in 2009 would have been more beneficial for my client if they had just proceeded on the foreclosure.
They couldn't. You filed for bankruptcy in order to prevent them from doing it. A lot of this, you know, I read your briefs, counsel. A lot of this I find to be less than persuasive on those subjects.
Yes, Your Honor. Well, I'm sorry. I appear to be out of time.
Yes. All right. Let me see if there are any further questions. No, thank you. We have your argument.
Thank you.
Attorney Goldsmith?
Yes, Your Honors. Good morning. I'm Michael Goldsmith from Edgartown for the appellee Nicholas ZUTRAU. I think this case boils down to sort of the essential issue of, did the motion judge have the authority to use the findings from the bankruptcy court in the partition proceeding in order to award all right, title, and interest?
Well, let's assume that the judge did.
Very well.
What's troubling me on the partition action, and there's something different that's troubling me on the equity action, is that, and I guess the easiest way to explain this is if the property, without an understanding of, and I take it there was no evidence before the judge, as to what the value of the property was, it's hard to evaluate the exercise of even equitable considerations in the outcome. So if the property was worth $10 million, you know, we might not think that it was a proper exercise of the judge's equity power to allocate the entire equity, or, you know, half of the equity to the other side, at least on the numbers that I see here in terms of the debt owed, et cetera, et cetera. If the property's worth $750,000, then you might come out to a different outcome. But without knowing any of that, how do we affirm the trend, where it doesn't look like the judge considered any of the math, what I call the math? How do we affirm the judgment here? I'm not talking about the piece of it that transfers the interest. I'm talking about the piece where there's no consideration of the math. And don't we need a remand for that part?
I guess the answer to that is this was put before the judge on a summary judgment motion. In fact, what Nicholas argued at summary judgment was that primarily the judge should take up the equity case first and order the conveyance and dismiss the partition, as the Wolohojian case from the 50s.
I know, but we review summary judgment de novo.
Absolutely. And so that evidence was not put before the judge. There was an affidavit of Eric ZUTRAU that talked about some minimal expenses of money that he'd put in, but nothing about valuation. She had before her the valuation that they alleged in the partition petition of $900,000.
Right.
But she could also infer from the long and
But that's not evidence that the judge could rely on in summary judgment, I don't think, right?
I agree with that.
Because it's not verified, it's, you know,
I agree with that. It's just a number that
it's out there in the
parties put
complaint.
in a partition proceeding when they start, and sometimes there's hearings about what the sale number should be and all of that. But you can infer from the way the judge handled the case that she took into consideration the delay that the Mr. Eric ZUTRAU.
Lost value of money, I think all of
And all
those
of
things.
that. She took
But
it-
with, again, if the property's worth $5 million, you know what I'm saying? I mean, I don't know that you would be able to say, well, the judge thought there was $5 million worth of lost value of money.
$241,000 note, right?
Correct, in 2006.
Yeah,
And
six.
giving away $2.5 million interest would be a little bit disproportionate to a $241,000 note. I think that's what Judge Wolohojian is referring to in terms of resolving this as a petition matter.
Again, we may have a slightly Procrustean fit, as they said, as this court said in the Sanborn case. But again, it was Eric ZUTRAU who invoked the partition, okay? He was faced with a Superior Court case looking just to get authority to do a foreclosure. If that's what Nicholas decided to do, sure. There were prayers in that 2018 complaint that he should convey his interest over. But then it was a defensive maneuver that Eric invoked.
Sure, he tried to use something strategically that backfired on him, and that
He was
happens.
in default.
That happens,
And
yep.
that's what he did. And he put it before the judge in 241, 22, and 25, say that the overseeing judge has broad equitable powers to deal with all
Who
matters.
moved for summary judgment?
Nicholas did. He moved for summary judgment in both cases.
Yeah.
It was a consolidated memorandum and set of facts, largely based on the bankruptcy court's findings, which did in fact find that there was a misrepresentation in September of 2006.
Again, I keep, and I know Judge Wolohojian's asked the same question, I'm not sure that the misrepresentations really matter to what has to be decided here. You have a partition case where the question is, was it appropriate equitable remedy for the court to decide that 100% of the value should have been transferred to your client? You have an equity case, which is basically a suit on a note, right? It's saying specifically perform the obligation of the note. And when Judge Wolohojian's done with her questions, I'm going to ask you about what was in the record on summary judgment on the equity case, because that seems to me to be important.
So in the equity case, what I'm wondering about is how accounts are dismissed with prejudice, because there's not really ever a ruling on the merits,
Well, I think
as
that goes-
opposed to dismissed without prejudice.
I think that might go to Mr. Larkosh's suggestion that Nicholas ZUTRAU has remedies at law now. But the judge, even though on the basis that it was moot, dismissed the equity partition with prejudice.
I
He
know.
has no more legal remedies.
I know, but how is that properly dismissed with prejudice as opposed to just dismissed? I mean, the basis was not on the merits. Mootness is not on the merits. So how do you dismiss with prejudice? It may act as a bar in the future for lots of other reasons, like statute of limitations, but is it appropriate to dismiss on mootness, to dismiss something with prejudice when the grounds of dismissal are mootness?
I'm acting on the fly here, but it sounds like you're right, Your Honor. This, again.
Sometimes that happens to me.
Can I say that's
Motion
frequently
judge-
the case?
The motion judge came up with this this was through independent thinking.
I know.
As you can see from the record.
Yep.
Because she first awarded the interest to Nicholas on the equity case, and then without anything from anybody except a number of interlocutory appeals getting launched, she pulled back her own order and went back to her chambers.
So if what I'm hypothesizing is correct, what in your view would be the appropriate remedy here?
I think I'm not going to surprise you that the decision should be affirmed and that fees should be awarded to Nicholas ZUTRAU, not necessarily even under the note. There's also Section 25 of Chapter 241.
But that's a discretionary.
Yes, it is.
See, under the
Yes,
note,
it is.
you're entitled to it. I mean, under the note, if you fit the language of the note, it's non-discretionary, as I understand it. It's a contract. You'd have a right to reasonable fees.
I agree with that, but the judge did not.
But under partition, it's discretionary, right?
Absolutely, agree.
Okay. Can we, if I can, I want to talk about what was in the record on the equity action. And let's start with, did your client make demand that he transfer the property prior to instituting the foreclosure proceedings?
Yes.
Okay. And where is that in the record? Because I just looked thinking I knew where it was and could not find it.
Have to give me a minute.
Well, you know what? Let's, because we have a lot of questions. If you tell me it's there, you.
It's on page 40. There was a first demand on May 11th, 2009.
Okay. All right. Perfect.
Okay, and then there's one behind that, page 44 of the record. And we apologize on this record. There's multiple copies of many of the documents. because
Okay,
it's
so
attached.
demand is made, and that's in the, so it's in the record that demand was made under the note for the transfer of the property?
Yes.
Okay, and,
I don't want to be very clear. The second demand was the first step in the foreclosure proceeding.
okay,
But it also said, we've made demand, and if you can't turn it over and you can't pay, then we're going to go do a foreclosure.
okay.
Okay?
So, so now you bring an equity action, and your summary judgment papers show that you made demand as required by the note, and that no payment was forthcoming, right?
Yes, that's correct.
And that's what the summary judgment record will show. And what defense was lodged to that argument in opposition to summary judgment?
I can't rattle them off the top of my head. I believe prior pending action, statute of limitations are the two ones that leap off the page to me.
Okay, so we have a statute of limitations issue, and you addressed that in your papers?
Yes, I did.
Because I know you've addressed it in your brief in great detail, that it's less than 6 years when you cut out the time during which bankruptcy was present.
And I addressed it in a reply memorandum to the
Okay.
motion judge.
All right, and prior pending action would be a discretionary judgment by this court in any, or by the court in any event, I believe, under 12b-9, right? I mean, his argument is, you filed a suit on that note in 2009. That gets us into a whole question of whether or not that suit on the note in 2009 actually was on Note A or not. And I got to tell you, it's less clear than you think it is, and it's less clear than he thinks it is.
Okay, well, you know my answer on
Yeah,
that.
okay.
It wasn't. And
So that was all in the summary judgment record, could be decided as a matter of law. Let's put that aside for a moment, and then I want to ask you the question that I asked your brother. Do you have a right under the note to fees for your equity action and specific performance? Is that an action to collect on the note?
I'll be honest, I never wrestled with that one before. It seems to me, I mean, this note was not drafted by attorneys. It was drafted by the parties, I believe. As you know, it was witnessed by a notary at the Dukes County Savings Bank.
So that sounds to me like something, if we thought that this was a road that had to be gone down, and no one's made any decisions up here, I don't think, certainly not me, you would have to remand it and have somebody take a look at it. Does that sound
Yes.
right?
Yes.
Are there any other questions?
I don't.
I mean, I think a remand would not,
I have to say, and I never say this, I think you both have a sense that we have questions and various problems, but that pursuing this appeal may not be the solution. So It may not be, given the history, that this is a case that it would be worth your while to talk to see if there's a resolution, but it does seem to me like it might be worth your while. So if you want to do that, great. You can always send us a letter. And in any event, I am going to ask again that the appellant let us know if he actually does want a remand on the partition action. And if you could both let us know that within like a week, we'd appreciate it. You don't have to tell us anything. If we don't hear from you, we're just going to assume that things are proceeding the way they're going. Otherwise, that's, feel free to write. Is there anything, you still have some time remaining. Is there anything else you'd like to?
No, I mean, I echo it. It's been a long road for family members, all without a lot of resources.
Yeah.
And there's been too much litigation, and it would be a shame to have more. We think the motion judge handled it appropriately here and didn't make a mistake under the law. And we'd ask that you affirm, and I'll rest on my brief for the remaining points. Thank you.
Thank you both. We're going to take the morning recess at this point. We'll be back in 15 minutes, pretty close to that.
For all rise, please. Court is now in recess.
Good morning, welcome back. Our next case is 2022 P0403 JM versus MM. And we are just going to, I think it will be easiest, at least for me, if we can refer to everyone in their like marital status, like husband, wife. That might be the easiest. And for the children, I'll leave it to you as to how you want to do it.
Thank you, Your Honor, and I will try to remember not to use the parties' names. Good morning to the panel, and may it please the court. My name is McAllen Howe, and I'm representing the husband on appeal. And I start by noting that although the fact finder in any divorce matter should be afforded substantial discretion to fashion a judgment to address both custody and asset division, that discretion is not unlimited, and it cannot be founded on error or omissions. And likewise, any judgment should be supported by the findings and the evidence in the record. In this case, the Probate and Family Court oversaw competing complaints for divorce, which were heavily litigated on both sides for almost half as long as the marriage itself. The husband brings this appeal to address some fundamental issues of equity regarding the division of assets and the award of sole legal custody of the parties' two children, now 11 and 12, to the wife. The parties had a 7-year marriage. For purposes of asset division, the court included the duration of the litigation and time spent preparing the judgment. So for asset division purposes, the court treated it as an approximately 10-year marriage. What is troubling in the court's judgment is that despite 3 years of ongoing litigation where issues of custody were raised repeatedly on a motion basis, the judgment, which was amended to correct a few errors, effectively upended the 3 years of status quo under which the parties operated without a substantive explanation.
The statement you just made is pertaining to the custody issue?
To the custody issue, Your Honor.
So that's where you want to focus first, is on custody?
I think that from my client's standpoint, it is certainly the most concerning piece of it. If the court would prefer to start with the division of asset issues, which are a little more discrete and easier to tackle.
It's your argument, counsel. If you want to start with custody, that's fine. Let's talk about custody. The suggestion that there's no explanation, so I went and I read the judge's rationale, and it seemed to me that there was an explanation that wasn't hidden. The judge indicates that that your client was unable, or that both clients were unable to communicate effectively, and that there was quite a history of that, which is laid out in the rationale about their ineffective communication, and that therefore joint legal custody, the judge thought, was inappropriate. What's wrong with that exercise of discretion?
As an abstract, I don't think there's anything wrong with that. Where I find error in this and what causes problem, I believe in review, is that the court has internally inconsistent findings that are then not explained. And so we start with the GAL's recommendation that there is no reason not to have joint legal custody.
I was going to ask you about that. Is there any requirement under the law that a judge has to make a specific finding that he or she isn't going to go along with the GAL recommendation?
I don't know that there is a specific statutory requirement there. However, at least in the Ventris case, the court did note that the failure to explain the deviation was something that the court was considering in remanding for additional findings. The court does find that the parties do not effectively communicate.
And to put a finer point on the GAL point, which, I understand that if it were actually evident in the record that GAL made this recommendation and the judge said, GAL makes this recommendation, makes recommendation X, I'm doing Y, with no explanation of why, okay, that's something we should be thinking about. But here, the GAL said, if your client shows the ability to, communicate, and the judge says your client hasn't shown the ability to communicate without being less than appropriate.
To be clear, I believe in reading the GAL's recommendation, and certainly not to make light of or be dismissive of the communication issues on both sides of this matter, Your Honor. The GAL's comment about the joint custody and my client's ability to control his communication issues was, as I read it, is directed specifically towards a 50-50 shared parenting time, and was not limited to the legal custody issue. Where I find the internal inconsistency with regard to the award of joint
So
or sole legal
that's
custody.
what you just said, is that's your understanding of reading the GAL report? Do we have the GAL report in the record?
We do, Your Honor.
Because what I recall reading in the rationale was the judge's explanation of what the GAL report said, and I took something different away from that.
The GAL's report is in volume 2 of the appendix, and the parenting plan recommendations are on page 193.
Okay, thank you.
But let me make sure I understand your argument. You're challenging the award of sole legal custody to the mother, right?
Correct, Your Honor.
And you're saying, well, the judge didn't explain why the judge deviated from the GAL's recommendation on that front.
To be clear, and I should have stated it more succinctly, I believe that the lower court judge did not reconcile his internally inconsistent findings in reaching what is a very drastic departure in custody.
Okay, I don't know what internally inconsistent findings you're pointing to. I'm looking at paragraphs 150, 151, and it seems to me pretty clear why the judge is not adopting the GAL's recommendation, which, by the way, is just a recommendation, and the judge has got to, as we have said, must exercise independent judgment, right? Just
Agreed.
cannot
Agreed.
adopt the GAL's recommendation wholesale. It looks to me like the judge is doing exactly that, and then explains why in that paragraph 150. Why is that not enough?
So where I find it to be inconsistent is that the court premises this based on the parties' inability to communicate and effectively exercise joint legal custody.
And some other things as well.
And some other things as well, but does not then acknowledge other findings contained within the court's findings.
So
where
what?
the court notes that they are able to
On
exercise
occasion,
it
they have.
on education and medical issues, Your Honor.
So, okay, so that's, right, that's the province of the judge, weighs some things more heavily than the other.
I think that is true. It's the province of the judge to do that, but to do that without a reconciliation of how it.
So is let me ask you this, okay? So let's just say the judge didn't explain it enough. The remedy is not to vacate the award. The remedy is for us to then issue an order where we retain jurisdiction and we say, Judge, please explain why you did this. And in 2 weeks, we get supplemental findings.
I think that it would be appropriate to vacate and remand for the judge to explain.
See, the point is that I don't really hear you saying a reason for vacating. Well, I hear you saying there needed to be further explanation.
I do believe that
Okay,
that
so
is true. And that there's a
if we were to adopt that, that would just get you a remand for further explanation. And not even a remand where we divest ourselves of the appeal, a remand where we just say, Judge, please explain in further detail, if we think it's necessary, why you did not adopt the GAL's recommendation regarding legal custody.
As I read the record, I do believe it's more than that, Your Honor, because you have 3 years of a repeated affirmance of this joint legal custody, which the parties were able to
Well, you have temporary
use.
orders.
They were on temporary orders.
Right, there's no affirmance or anything like that.
Or a renewal then of the temporary award. The other issue that I have.
What is it that you say is in the judge's findings that's inconsistent with his conclusion in 151?
I feel that there are two components to that. The first is the failure to acknowledge the effective exercise of joint legal custody, which are contained in, I believe it's findings 114 to 124. There's a list of both educational and medical issues which the parties were able to reach agreement on for the benefit of both children. The other component of it that I feel is problematic is that the lower court recognizes multiple instances where wife exercised unilateral decision-making authority while the parties had temporary joint legal custody.
And which are those? Is that the decision to put one child on certain medication that was ordered by a doctor? Is there anything else?
Yes, Your Honor. So that was finding 117, where in response to husband's objection, wife continued to administer the medication for approximately 6 weeks. In finding 118, the wife undertook to schedule.
But how does that, I mean, what that indicates is, yeah, the two parties aren't communicating well. It doesn't really help you. It's, unless you're suggesting that the error was not that it should be joint legal custody, but that it should all be the husband's legal custody. I mean, it's another indication that they're not communicating about the child's needs.
In these instances, Your Honor, it is an indication that they're not communicating, but the failure to communicate in those instances was on wife's side and not on husband's.
But you understand my point. I mean, there's also, you know, of record, husband will not take any communications from wife other than by email, right?
That was correct at the time of
Okay.
trial, Your Honor, in an effort to reduce the conflict. So that was his approach to
And
addressing
will not
it.
allow the mother to communicate with the children during his parenting time. That was the evidence.
There was testimony as to that. There was also testimony that the children were able to communicate by phone.
All right, well, the judge made certain findings that we're bound by.
As I see we're dwindling on time, and there are a number of asset division pieces, I would like to turn to that.
Sure thing.
And I believe that some of those are predicated on clear error, which make a problem in the fundamental fairness and equity in the division. The parties, there was no adjustment following the husband's motion to alter or amend the judgment, where he raised some issues and on appeal raises additional issues regarding the asset division. The first piece that I would like to address is that the judgment fails to consider or treat wife's irrevocable or wife's vested interest in an irrevocable trust as an asset of the marriage. I agree with wife's position that the court had the authority to award her that interest. However, we don't know what impact that could or could not have had on the ultimate division of assets, because the court simply didn't consider it as an asset. It looked to the wife's interest as an opportunity to acquire future income or assets, but not as a vested interest.
It did take the amount of the first payout into account.
It did not, Your Honor. It's not counted in any tally of the marital assets to be divided. So wife does not receive credit for receiving that asset. There's no offset against what husband owes her.
But there doesn't have to be there does not have to be an offset. Your point is that the error is that the asset's not included in the estate, for at least as the judge approached it. But is there any indication of prejudice from that?
Well, I believe there could be, Your Honor, because being
$40,000.
silent is an issue that's being omitted, then we don't know if that had any approach. I don't know whether the judge intentionally meant to award it to
Did you ask
wife
for
and didn't
clarification from the judge down below?
I don't believe that was raised in the motion to alter or amend, Your Honor.
All right, so you're raising this for the first time on appeal?
We are.
There are other much more substantial assets of the husband that weren't included, right?
There are, which were all premarital, and one of those, which I would also like to touch on, was the treatment of his South Boston rental property, which was a three-family that he acquired approximately 13 years before the marriage with separate funds, and which was maintained with separate funds. Wife was awarded a 25% interest in the equity of that home. Although my client disagrees with that, he's not challenging that on appeal. What he does challenge on appeal is the valuation of that property. The court adopted whole cloth, wife's real estate expert's appraisal of that at $1.6 million. I think we have two issues with the treatment of that property. The first is that wife's expert testified that he considered proximity and age of comparable sales to be the dispositive or the weightiest factors. And when he was asked on cross-examination and then on redirect as to why he didn't include two comparable sales, which were hundreds of thousands of dollars lower than the ones he relied upon, and which were as close as the ones he relied upon and the same age as the home, wife's expert testified simply that he couldn't recall and didn't know. The court adopted the comparables relied upon by wife's appraiser, included them at length in the findings, and simply did not address the fact that there were significant factors which undermined that appraisal number.
Okay, we're going to have to leave that there because your time is up. Let me see if there are any further questions. I don't see any. Thank you. We have your
Thank you,
brief
Your Honor.
and we have your
I'll rest on the brief
argument.
for the remainder of the
Great.
asset issues.
Thank you.
Good morning. May it please the court, Dana Curhan for the wife. Let me start with the issue of custody and visitation. It's our contention that the judge did not disregard the GAL's recommendation. The GAL recommended joint legal custody. However, that recommendation was based on the husband's modification of certain negative behaviors, which continued and occurred even during the course of the trial. I think there were...
Your opponent says that the condition actually wasn't with respect to joint legal custody. It was with respect to whether they would each have 50% parenting time. And the only quote I see in the opinion seems to be consistent with what your opponent says.
I think if that is in fact the case, the judge had ample reason and provided a very full explanation of why he wasn't following that recommendation of joint legal custody. I mean, here's the problem. I think there are at least two sets of behaviors that are really deal breakers in joint legal custody. The first is his behavior at the pickups and drop-offs is continuing to disparage her in front of the kids. There are numerous paragraphs in the findings.
But why does that undermine joint legal custody? That might undermine how they pick up and drop off the children. But I mean, joint legal custody, as I understand it, has to do with making the major decisions in the children's lives, right?
Well,
it doesn't have to do with who picks up and drops off and how they behave.
If they can't have a civil conversation without hostility and F-bombs going back and forth, well, not back and forth, F-bombs going from the husband to the wife in front of the kids, how does that show that he can make reasonable decisions on behalf of the children? That is one part of it. The other part that I think is very concerning is that the husband has blocked the wife's phone communications. So if there's an emergency, she can't call him, she can't text him, she can either email him or she can call his brother and have his brother call him. And that really is not, does not suggest effective communication between the parties. The judge also expressed some concern that the father is not making appropriate decisions for the children's safety or health and education. For example, he would cancel a lot of appointments. The wife would make appointments. She'd show up and find out that the appointment was canceled. She had some neuropsych testing done on the daughter, and the husband said, you know, you had no right to do that, and you can't release it, so that the results, as of the time of trial, still had not been released. You know, these are all concerning things, and these are all appropriate grounds in which a judge could say, I don't think they can communicate effectively. Whatever the GAL may have recommended, I don't think joint legal custody is appropriate. And I also think that the GAL was very concerned about some of these behaviors and said they had to stop. Now, if I don't recall specifically if the GAL said this is only appropriate on the issue of visitation.
Well, she didn't say it that way, but as I read, I don't have the GL in front of me, but as I read the findings, they're consistent with what your opponent said to us, that they are related to 50% parenting time. That's the way it's written. In other words, what the GAL said, she said, the husband first needs to demonstrate that he's able to refrain from making disparaging comments before the children spend half of their time with him. That's the quote.
Okay, I do think that when you look at all of the findings, and there are numerous paragraphs, maybe 15 or 20 paragraphs that discuss this behavior, I think that's equally applicable to joint legal custody. And I think the judge was absolutely right in saying it's not in the cards here. You know, I think that the communication issue, how do you make decisions if you won't communicate? If you refuse to communicate, if you can't have a phone call, and if you don't let the children talk to the mother, you know, on their birthday, for example, or during his visitation time. And I think there's really an amalgam of factors here that support the judge's finding.
Can we just, on the asset, your opponent talked about the $1.6 million valuation, and I understand that you had an expert, they did not. But she says, look, there were two comps that were much lower. They were presented on cross-examination. The judge never even addressed them. What do you say to that?
I mean, I think the comps were different. You know, there are, when you look at all of these comps, some of them had more bedrooms, some of them had more area, some of them were in different locations. You know, for example, you know, this was...
Did your expert, did your client's expert address those comps at all in his testimony?
I believe he did, but he, you know, when you look at some, you know, for example, we have fewer bedrooms than one of the comps. But on the other hand, each unit in this 3-unit place has a den, and one of those dens has a closet. So it's probably more like the one with 3 bedrooms than it is with the one with 2 bedrooms.
I'm just trying to focus. Look, you know, I understand the argument which you make in your brief, which is this is a finding fact.
It is.
And it's subject to clear error review. And I understand all that. On the other hand, you know, I'd like to see experts address all the issues that they should be addressing before they reach their opinion. And that's all. So my question was, they point out 2 comps, which they say are closer in proximity and much lower in value. Did your expert address those?
I believe our expert addressed that. I can't give you a specific page, but I believe our expert did. I know in his report he did. In the testimony, I don't recall the specifics, but I believe he did.
All right.
And, you know, we're essentially what they're saying is it is, sometimes you're comparing apples and oranges. I believe the judge, the expert had a rational basis for coming up with the value that he did, and the judge could say, yeah, $1.6 million is accurate, and I don't have to take, I mean, essentially the husband said, well, I got an appraisal of $1,250, which you don't have, or $1,250,000, which you don't have, and I'm deducting $200,000 for the condition of the property. Judge was not required to accept that position. Are there any other questions as to the asset division? I mean, I think everything is based on findings of fact. You know, I could get into the weeds here, but I'm not sure if it's...
Does the judge actually not include the wife's vested interest in her trust in the estate?
That's right. He does not do it. The mother died during the course of the trial, and the...
Or during the course of the trial, or during the course of the litigation?
I think it was during the trial.
trial.
The trial went on for quite a while.
Oh, okay.
The trial went on over the course of over a year. I think there were 7 trial days in
I remember.
2018 and 2019. The wife's mother died. Those assets were not part of the marital fabric. One thing that the judge also...
Is that the test?
That is generally the test.
Assets that are not part of the, I mean, it's an asset acquired during marriage.
There's a line of cases saying that if it is not part of the marital fabric, the judge has a right to exclude it. Now, one of the things that...
But that involves a decision that says it's part of the estate, but I'm going to exclude it, not, it's just not part of the estate.
The judge also did that with the husband, with his mother's apartment.
Mother's condo, yeah, but did he, but I think what your opponent would say is that that's the way you're supposed to do it. You acknowledge that it's part of the estate, and then you make the decision that you're not going to divide it for whatever reason, in that case, because it really had nothing to do with the marriage. It was mom's apartment.
I mean, that's correct, but, you know, when you look at that asset, that is a piece of real estate with no mortgage, and his mother was living in it, and she was 85 years old about that at the time of trial. So at some point, he is going to get that unit back and presumably sell it or do whatever he wants to do with it. The judge excluded that, and we're not objecting to that.
Right.
But I also think that the trust is going to be $20,000 payable immediately, and then $20,000 each of the next, every 5 years. I think the judge was well within his discretion in saying, I'm not including that in the marital estate. Again, it was not part of the marital fabric, and the judge so found. Unless there are questions on any of the other points, I can talk about any of these other assets, but I think they're pretty well covered in the brief.
I don't see any, so thank you both. Thank you
Thank you.
both for your arguments and your briefs, and the case is submitted. The next case is again impounded. It is 2021P119. I'm going to call it KM versus RD. So here again, let's just refer to the parties as wife and husband and any other kind of
Understood.
name like that, that will keep the parties clear but not refer to their actual names.
I will do my best, Your Honor. Good morning, Justices. My name is Greg Assetto, and I represent the wife, the mother in this matter. And this is a really distinct issue about whether or not my client has the right to pursue a motion for relief from judgment under 60B6. As is clear in the record, my client filed a motion under 60B, and the arguments were under 60B6. And the judge denied the motion, saying that it had not, under 60B3, had not been filed within 1 year. And so it wasn't the thrust of the motion. The motion was under 60B6, and as I'm sure the panel understands, under 60B6, we have the right to seek relief from judgment under the catch-all rule. Any other reason justifying relief from the operation of the judgment gives the court the authority to entertain an independent action to relieve a party from a judgment or to set aside a judgment for fraud upon the court.
You would agree that a judge is not bound by what the party titles the motion, correct?
Correct.
So what justification was there in this case for bringing the claim under 60B6 as opposed to one of the delineated reasons in 60B, 1 through 5?
Right. So I understood early on, Judge, that that it was the other provisions are limited to a 1-year look back. So I'm not going to mislead you. The only one I knew that we could proceed on was 60B6. So
did you take a look at the law? You do cite Sahin against Sahin in your brief.
I do. And
so isn't the law that if it falls within 1 through 5, you can't use 6 because 6 uses the word other?
I agree, Judge, but it also talks about the fact of balancing the competing needs for finality and flexibility to be certain that justice is done in light of all the facts. And the cases that I cite in my brief talk about the fact that if there are compelling or extraordinary circumstances...
That's a fraud on the court argument.
Yes, I understand. Well, it doesn't limit it.
Not a 60B6. Fraud on the court. It's a different argument. It's that extra sentence that appears in Rule 60B.
Right, and in this case, we believe there was evidence of a fraud on the court that it started off with the husband not turning over tax returns, not turning over 1099s as he was required to do under the agreement.
Isn't that fraud against the adverse party when you don't turn over documents to the opposing side?
That's true, but
that would be under 60B3.
Correct, Judge.
So when does it turn into, in your argument, a fraud upon the court?
Well, the financial statements are signed by the attorney, and there are case law that says that the attorney, and I'm not saying that, and we have a very good relationship, I'm not saying that she knew what was going on, but she signed the financial statement authenticating the validity of the statements.
Well, if you're not saying she knew what was going on, it doesn't sound like a fraud.
Well, she said that to her knowledge...
She signs the statements because that's what she's intended to do, and your opponent says, the signature actually says, it's true to the best of my knowledge, or something like that, right?
I agree. But so the fraud on the court, though, it's not limited to just that scenario where the lawyer is involved. In this case, it went farther than not telling the court...
Are you familiar with the decision in guardianship of Ingrid?
No,
I'm very familiar with it since I am the author. It came out about 45 days ago. It's on exactly this point. It addresses exactly these issues.
Just 45 days ago?
Yeah, maybe less. Also, are you familiar with Judge Wolohojian's decision that also addresses what fraud on the court means?
Yes, I am.
And goes into it in great depth. I think it's called Mount Ivy.
Yes, I am familiar with that.
Again, not cited in your brief that I saw, counsel?
Well, this goes beyond not disclosing all the facts. He made significant amounts of money. It doesn't seem fair to the litigant that it was not disclosed that he made over $360,000.
So he lied, is what you're... I mean, what it boils down to is he lied. Where in the case law is it that when a witness, in this case, your client or the other client, lies to the court, when does that turn it into a 60B6? That's what I'm missing from your brief, that a lie turns into a 60B6 argument.
I don't have that because there's no case that supports that, but this was so egregious in the amount and the extent of the deceit that it seems like there should be some remedy that the court can administer, because not only
Well, there is a remedy, but it has to be sought within a year.
And that's the problem that I have, is that it was concealed throughout that time until I got involved in 2021. And
you say it's concealed, but I got to say, this is nothing close to cases that might be fraud on the court, because this is really, the way I read it, a fight about whether the discovery was adequate. And I don't see the motions to compel. I don't see in your record, you know, you say, oh, this document wasn't produced, and you know he didn't include when he actually produced what I think you say is an accurate 2015 financial statement with respect to gross wages. He left out of it some other things that should have been there.
Yes.
Why isn't that exactly what discovery is about? That's what discovery should bring out.
I mean, I've been doing this a long time, Judge, and the financial statement, you do rely on it, and there's a specific provision that says deferred comp, and he put zero. This wasn't like a $5,000 bonus. This was $60,000 in deferred cash incentive that
I
he was
didn't
getting.
get that. That was very succinct and very clear to me, and I was looking for that in your brief. So in his financial statement, it says deferred comp, $0.
Yes.
And in fact, he received how much in deferred compensation?
Well, up until the time of the trial in April 2016, he had received $120,000, $60,000 on April 1st, 2015, and then the second day of trial was after April 1st, first one was April 1st, 2015, and another $60,000 April 1st, 2016, days before the second day of the trial. He had to sign this as part of the...
How much had he received when he submitted the financial statement?
That's in the record appendix. I can direct Your Honor to that.
So, in other words, we can't look at amounts he received after he completed the financial statement. If he says on the financial statement on day one, I've received $0 in deferred comp, that doesn't become false unless he received the deferred comp before that date, correct?
No, if I could go back, I would say the deferred comp is the deferred comp, which was $60,000 he got on April 1st, 2015, and another $60,000.
What was the date of the financial disclosure? When was the financial disclosure executed?
There was two of them. The first one, the record appendix, page, let me just find the signature page, was February 12th, 2016. That's record appendix 112. The second
And so when did he receive, and that one says $0.
They both say $0, yes.
Okay, so as of February 2016, had he received any deferred comp?
No, he received.
Okay, so then let's look at the second one. When's the date of the second?
Record appendix 129, March 29th, 2016.
Okay, and March 29th, 2016, had he received the deferred comp?
It started to vest on March 1st, 2000. I misspoke. It wasn't April. It was March 1st, 2015. It started to vest.
What does that mean? Had he received it?
Well, I subsequently learned at the trial that we had earlier this year that it invests, I learned from MFS representatives that invest, 1/3 of it invests every year. But he gets $60,000 each year, so as it continues to grow, the deferred comp, he gets.
So you're saying it vested, it hadn't been paid out, but he was entitled to it as of March 1?
Yes, correct. It had not been paid out yet, but it had vested each year. So $20,000 for each year that he got the deferred cash incentive, $20,000 of it vested. So after 2016, he was getting $60,000 in vested compensation that was never disclosed all the way up to the time of the trial. And so it continued to multiply, on top of which he was also getting deferred stock to the tune of $40,000 to $50,000 a year, all of which vested over a 4-year schedule, which was not disclosed to the court, the amount of it. Now, he did...
But wait again, we would have to go, so when you sort of paint with a broad brush like this, Judge Wolohojian's questions are the questions that we would all have. Show me the fraud. The fraud has got to be...
Fraud on the court.
The fraud has got to be, this document was presented to the judge, it says X, it's not true, it's demonstrably not true because as of that date, Y had already occurred. Now you say there's something on March 29th, 2016 that says he received $0 in deferred comp, and in fact, as of March 1, he'd vested $60,000. Are there other examples as specific as that?
And I wanted to direct Your Honor to a record appendix 136 and 137. He received deferred cash awards on March 1st, 2015 and March 1st, 2016. Now, these are deferred, but he got them and he put $0 in his financial statement.
Well,
and
put
he signs
zero next to what?
Next to deferred.
He hadn't yet received them. These are awards. He hasn't received the income yet. What did he put? How did he not disclose those?
Because,
or how did he say something to the court about those that was false?
Well, the financial statement says deferred compensation.
Which
It doesn't-
date?
I'm sorry?
Is this the March 29th, 2000? Okay.
Both of
So
them.
those both predate these forms of income you're identifying,
No,
right?
the second one was after March, no, excuse me, they both are after the March 1st, 2015 award. The second one was after they both predated the 2015 award, both financial statements. The March 1st, 2016 statement also predated the March 5th, 2016 financial statement. So they were both before the financial statements, and he got that award. It's deferred comp, and the entry in the financial statement says deferred comp. It doesn't say vested deferred comp. It says deferred comp, and he got these awards. He signed the certificates for them on March 1st, 2016, and March 1st.
But deferred, it's an income statement, isn't it?
The financial statement?
The financial statement is a statement of his income, isn't it?
But these are awards that are given to him, and they vest, so they're contractual. They vest. He knows they're going to vest each year on the anniversary date, $20,000 portion of each one of these certificates. So it's still money that, otherwise, why have deferred comp on the financial statement if it's not part of the analysis for the judge to consider?
So let's assume that the statement on the financial statements on deferred comp was false and also knowingly false.
Mhm.
I don't think that's normally enough to get you fraud on the court. Do you have a fraud on the court case that is the closest on the facts to that?
And no, I don't, Judge, but I've never seen one to this extent, the amount that was not disclosed to the court.
But fraud on the court doesn't depend on I don't think, on the amount of the dollars at issue, right? It turns on the difference between fraud and fraud on the court. It has something to do with the quality of the behavior.
Where it can be demonstrated clearly and convincingly that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability impartially to adjudicate a matter.
And this goes back to what I was saying.
For
is that
example.
He didn't turn over, thank you. He didn't turn over documents. He did a deposition. He didn't discuss these things. This set this whole scheme in motion, and then at trial.
You say that this is large, but I got to tell you, you've obviously read the Sahin case. Sahin was hundreds of millions of dollars.
But I distinguish that case, and I thought you would bring that up. I distinguish that case because, in my experience, there's always a fight about the value of a business, and especially if it's a family-owned.
But this was hundreds of millions of dollars.
I agree. But it's different.
That's pretty significant difference. I mean, if we're talking about a fight over value of a business, your $40,000 here versus his hundreds of millions of dollars there. I think his is a little more significant, isn't it?
But I'm not focusing on the money so much as the subjectivity of it, because he argued, the husband in that case argued that it was worth what it was, and I think they even both put on experts to argue about that. Her position was, the wife's position was 3 years later, the property sold, and it was for, like you said, $1.4 billion. But in this case, it's not a subjectivity issue. This is clear that he didn't disclose this information. $360,000 worth at the time of trial. Some of it was deferred comp, I agree, but he continued to receive it, so it had its repercussions.
So under your theory, under 60B6, whenever there's a lie that has substantial, whatever that means, amount, this can always be brought. So litigation will never end.
Man, I understand the public policy behind it, Justice, but in this case, it's so clear to me that there was a scheme on the part of the defendant, the part of the husband, to mislead the court. That I just can't believe there's not a remedy for my client to this amount. It wasn't just
There
for
is,
her.
within a year, as Judge Wolohojian pointed out. I mean, we've got a very specific rule about it, and I understand the concern, but judgments have to be judgments. Judgments are things that you rely on, and you have a trial and you have discovery so that you get to a point where you actually have a judgment that ends the matter, and you have a year to show your fraud.
But in a divorce case like this, it's different because it continued. He had a duty to turn over 1099s, and he refused to do it until I got involved. That's why
I have a question for you on that, which is some of the concerns you raise are not related to what happened in 2016. They're related to things that occurred after 2016. Don't you have the ability in the modification trial that you're in to have retroactive relief?
And I have pursued that, yes, but I couldn't let this go because I had 30 days to file an appeal. But I am, you're correct, I am pursuing that in the modification trial that we had. I don't think I ever said otherwise, yes. That is true. I have raised that issue. I don't know where the judge comes down. We have not got, unfortunately, we were talking about this earlier, we have not gotten a ruling from Judge Jacobs on that. So I don't know where that goes, but I had to preserve my right here. Thank you. I noticed that I'm out of time, and I appreciate it.
Yeah. Thank you very much for your argument.
May it please the court, I'm Joanne Romanow, and I represent the appellee defendant husband. I've actually been involved with this case, if you look at the docket, since 2006, 2007. I have a long history. Yes. And I have to say, I was surprised when this motion under 60B6 was filed by counsel. There are no facts or law that support it. I see it as frivolous. Issues are well settled. The law is well settled. You know, the mother, wife, did not like the judgment at issue and is once again trying to resurrect it, and we're trying to relitigate it. As the court has noted, there's 6 reasons, including newly discovered evidence, fraud, misrepresentation, and of course the catch-all 6 for any other reason. This judgment entered June 28th of 2016, and the motion was not brought until July 6, 2021, more than 5 years later, which is clearly beyond the 1-year limit. It's set by statute. It can't be expanded.
He says your client in 2016 submitted to the court a financial statement, which is required under the rules, which said he had 0 in deferred compensation when he actually had apparently hundreds of thousands, at least 60 plus other things. What do you say to that?
I dispute it. You know, I mean, I'm running through.
I'm sure you dispute it. Now give us a reason why you dispute it.
The record to find out where the line was for deferred compensation. I know he referred to it in footnotes in his financial statement. And I also know that Judge Nisi, in his findings of fact and rulings of law in this matter after the 2016, I think it was 2016 trial, specifically referred to the deferred comp. So it's not as if it wasn't an issue that wasn't out there and wasn't known about.
Well, let me put a fine point on the question. Is there a line, as your opponent says, in the financial statement for deferred compensation on March 29th of 2000 and I forget if it's 15 or 16, that says deferred compensation $0.
Well,
and does that exist, and B, was that truthful? Or was there in fact already at least $60,000 in deferred comp that he'd received that year?
I am looking at the financial statement, Your Honor, from March of 2016. And there is
What page are you on?
Yeah, there is. There's a line that says deferred comp.
What page are you on?
I'm at the record 127, but then I look to the footnote, which is at the record 132, and footnote 2, the plaintiff earned $453,000 and change in 2015, which included a salary of $170, cash bonus and other bonus payments, quarterly dividends, and DCIP, which was as well as his deferred compensation of $23,800. We reported it, Your Honor.
Thank you.
The plaintiff wife has failed to allege any facts that would constitute a fraud upon the court. There's got to be something egregious conduct, you know, examples in the case law are bribery of judges, employment of counsel to influence the court, bribery, and the involvement of an attorney in the perpetration of the fraud. Thankfully, counsel doesn't suggest that I've had any involvement with that.
It is not.
Which is good. It has to show that there was some unconscionable scene in place, a non-disclosure of facts without more doesn't constitute a fraud in the court. And by the way, I'm not saying there was a conscious non-disclosure. I just read to you the line from his financial statement about it.
Can I ask you about the pending modification?
Yes.
Are any of the issues or arguments that are raised here being litigated in the context of the modification complaint?
Yes, you know,
They are.
and counsel has raised them in his request for rulings. I've opposed them in my request for rulings, and it's going to be in Judge Jacobs' discretion to tell us what we're going to do next.
Well, I mean, we don't want to have inconsistent decisions here. So when was the modification complaint tried?
Our last day of trial, I believe, was in March of this year. I can't give you the exact date without looking at my calendar.
And what are the overlapping issues?
The issues before the court in the modification is to be the amount of child support to be paid, either retroactive to the date of mom's filing, and then going forward, there are 2 children still unemancipated, both in college. So that's one of the issues. Another issue, and again, I'm kind of off the top of my head, is how much my client should be contributing towards college.
Okay, so maybe my question was very poorly phrased. Maybe what I'm trying to get at is, even if we assume for a moment we were to affirm the denial of the Rule 60 motion, I take it you're not taking the position that that would have any collateral effect on the judge's consideration in the modification complaint as to what the appropriate amount of contribution is or child support is?
I think it's before Judge Jacobs right now. I think what Judge Jacobs didn't want to get bogged down in vacating something, a decision that's almost 6 years old.
So the deferred compensation issue that opposing counsel talked about, and is really this appeal, that is not subsumed in the modification.
Well, I know arguments been made that this deferred comp should be considered by Judge Jacobs when she makes her findings as to the amount of the support, the amount my client pays.
Well, that wouldn't be inconsistent even if with even an affirmance here, because it seems to me, right? Because the judge can take everything into account in setting child support or support.
That's what I've told my client.
Okay. All right, that's helpful. Okay. That's helpful.
You know, at this point in time, I would, and the other thing that I think is somewhat relevant is if you look at the parties' agreement, there was a $400,000 income cap to the support to be paid. And Judge Nacey was very clear, you know, that's, folks, that caps it, you know, and I'm not, in his findings, and I'm not going to change the cap. And
He said that in his findings.
he said that was.
Because your opponent says at some point during trial, the judge said, well, of course, I could always change the cap. Can I ask, the cap was agreed to when? Back in 2010?
10.
So initially, the parties had an agreed separation and divorce judgment. Is that right?
Yes, we
Okay.
did.
And that's where the $400,000 cap appears.
That's exactly it.
And your point is, look, all of this is a tempest in a teapot because he was always at $400,000 throughout this period. And so the extra money was irrelevant.
That's my view of it. And very frankly, our trial judge, whose name just flew out of my brain, Judge Jacobs, certainly is entitled to look at deferred comp and whatever when it comes to should there be more money my client's contributing towards college, or should there be more towards support. Alimony actually ends this year, according to the
Isn't the
agreement.
cap, I can't remember the law on this, you can't cap the child support, right? The child support is always able to be reconsidered. Is the cap enforceable against alimony? Or does the judge have the ability to reconsider alimony as well?
Well, we can try reconsidering alimony, but I think the cap is enforceable as it relates to alimony.
Okay, that's what I thought.
And frankly, the issue's going to die as of December 31st of this year. Alimony disappears. So it's really going to be what he's ordered to pay.
The last child has almost reached 23 at this point, hasn't it?
Pardon?
Hasn't the youngest child almost reached the age of 23?
That's correct. We're getting there. Court have any other questions?
Nope. Thank you for your argument. Thank you both. We've been aided by your good arguments and by your briefing. And with that, the case is submitted.
Thank you.
The next case is 2021P0840, Philip Ryan versus Gardner Franco-American Federal Credit Union. Mr. Ryan, we're ready whenever you are.
Your Honor, there's a motion that was filed some time ago. The single justice deferred to the panel concerning materials that were filed.
We saw that. We'll act on that in due course.
Okay, thank you.
Good afternoon. Thank you for allowing me to argue my appeal. I just found out about them trying to take some stuff out of my brief and appendix that wasn't filed in land court.
Right. If it wasn't filed below, it can't be part of the appeal.
Respectfully request to file a 16L letter.
Well, if you have grounds to file a 16L letter, which you'll know after the argument, presumably, then you'll submit a 16L letter, and we'll act on that then. We can't rule on a 16L letter in advance.
Okay. I filed a petition in land court. It is not limited to a foreclosure only. I mean, I put a request in to certify the property lines. If the property lines don't close, it doesn't qualify for a mortgage. I'm not sure if that was in land court or not. They're saying, and then outside of that, they're saying, I've already argued a foreclosure. And if you look at all my documents, clearly there was no auction to even argued. It wasn't. The auction failed. The auction fell through. I had a meeting with Craig Toohey. He told, there was two different stories. Craig Toohey told me the bank pulled out of the auction 3 weeks after they had the auction, April 8th, 2016. They pulled out because they couldn't get clear title. That's what he told me. The bank sends me interrogatories. Question number 11. I believe it's page 42. What was said in your meeting with Craig Toohey? So they knew I had a meeting with him because he went running to the bank and told the bank he had a meeting with me, and they told him never to talk to me again.
So I understand the difficulty with someone who has to argue their own case like you do, but the issue that we have to deal with is you'll see it as a process issue, but it's actually an important process issue. You filed a lawsuit against the bank in Superior Court. You said basically they've committed a fraud or they've committed unfair and deceptive trade practices against me in the way that they handled this. And in response, one of the things that the bank said was, we would like to quiet title. We would like it confirmed, our title to this property. And that went to judgment. And the problem we have is once that goes to judgment, similar to what I was saying, judgment has to mean something. And having another shot at it is what we don't like because we like judgments to end things, to have finality so that we don't repeatedly relitigate. And that's the concern that the judge in the land court was trying to address. Now, you know, I'm interested a little bit in how the Superior Court case went. As I understand it, the defense that was raised to your claims was statute of limitations, right? That you'd waited too long.
Attorney Conley informed the judge that the bank can only commit 93A one time, and that's it, it's done. They can't commit it again. And that's not true. Every time the bank commits 93A, there's a 3-year statute of limitation that's added on.
What would you say the bank did again?
Once again,
I mean, the biggest thing that you were arguing about, as I understand it, correct me if I'm wrong, was that the lawyer who was retained to certify title at the time of the closing made a couple mistakes.
Yes, sir.
Right?
Yes, sir.
One of which I think you've resolved involving the septic system, and one of which you haven't been able to resolve involving the metes and bounds of the property.
Yes, sir.
What did they do after that that was?
They just denied everything. The bank, they just denied everything.
No, but after the title, the person who certified title, which was in 2003, correct?
Yes, sir. Amen.
Yes. In 2003, the errors made by the person who certified the title in 2003, that was the basis for your Chapter 93A claim in the Superior Court. Is that correct?
No.
No? What was the basis of your Chapter 93A claim?
They refused to acknowledge the deficiencies. I had everything except Attorney Roberti's title report, independent title report at the time. Well,
So you're saying they had a duty to acknowledge the mistakes that the lawyer had made? And to do what?
I think they have an obligation to get an additional independent title report that contradicts what Jim Roberti said.
But I
Not just say,
have a hard
no way.
time understanding fundamentally, and I may just be missing something here. How does this error help the bank? They lent you money. So they've lent money on a property that there's some cloud on title. There's some cloud on title because there's a septic system that goes onto another property. The property line may not be correct. That doesn't help the bank because their money is in the game on this property, and there's a cloud on the title.
They sold the note to Freddie Mac, June 12, 2003.
Again, then is the problem with Freddie Mac? Freddie Mac's lost? How have you lost out by this error? As opposed to, and with respect to the bank lent you the money.
Yes, they did.
It has not recovered the money. Because you stopped paying the mortgage back in when? 2015?
13.
No, 13? Okay.
I believe
13.
March 15?
March or April 2013. Okay. So how have they gained from this error vis-a-vis you?
How did they gain? I made $100,000 in payments. I put $60,000 down, and I spent $80,000 getting a piece of land where the septic was, thinking that was going to end everything. The septic, and then I called the bank up and I said, hey, you want to help me out and reimburse me the money? Because I bought a home that doesn't meet the minimum requirements for habitability. You can't live there without a septic system. She said, shut up, you're not getting 1 red cent, and attach the properties, point blank. That's what the bank said to me. I'm like, you kidding me? You sell me a home that doesn't meet the minimum
No,
requirements.
the bank didn't sell you a home. The bank
Robert
gave you
Van Dyke
money,
did.
and you agreed to pay the bank back.
I did sue Robert Van Dyke, who was represented by Keith Glennie, that's in the courtroom today. So he's well aware of what went on.
What has the bank done wrong? I guess that I'm missing that. What has the bank done wrong?
They failed to help me out.
Well, what obligation do they have to help you out? You borrowed money from them, they gave you the money. They did what they were supposed to do. So why do they have to do anything more?
I signed a series of papers during my closing, all favoring the bank. We want this, we want this, we want this. Fine. What you're not looking at is the other side. The bank's saying I clouded the title. That's what screwed up the auction. Oh. The property doesn't close. The septic is on someone else's property. The southwest section of the leach field is too close to a third person's property, and it's also too close to their drinking water. Those issues cloud the title. I went back repeatedly. What are you going to do? What are you going to do? I said, look, there are just too many issues. Buy me out and I'm out of here.
Why is this the bank's responsibility?
The bank hired George Corey to check the accuracy, the history accuracy of all the property lines. He did not. He said in his...
So that's a lawsuit against George Corey.
He represents the bank. He's working for the bank.
But that would be a claim that the bank has against that person. Not you. You can't enforce the bank's rights against that person. Your obligation, I mean, I may be wrong. You took a mortgage. Your obligation is to pay the mortgage according to its terms. You stopped paying the mortgage in 2013. There are certain consequences to such a decision, including the bank's right to foreclose that on the property, right?
If they follow the statute to foreclose, sure.
All right. So then they have a foreclosure, and the first purchaser backs out. There's additional litigation, but your claim in the Superior Court against the bank ends up being dismissed. You appeal that dismissal. The dismissal is affirmed. You could have raised all of the arguments you're raising now in that first suit. They were all knowable because the events occurred back in 2003, whatever, and presumably before you stopped paying on the mortgage, because my guess is you stopped paying on the mortgage because it made economic sense to you to not keep putting money into this problematic property, correct?
Yes, ma'am.
So all of the claims you're raising now could have been raised in your 2017 Superior Court case. And that's, I think, the crux of the issue here, which is, if that's the case, why aren't the current claims barred by res judicata?
The claims that I'm making now?
Mm-hmm. Because you could have raised them then.
Attorney Conley said it was a perfectly good home to sell. There is nothing wrong with it.
Which attorney?
Attorney Conley.
That's the bank's lawyer?
Yes. He works for PB and Arnold.
So what's the status now? It's been sold to a third party. Are you still on the property or no?
No, that's unusual. I was evicted 3 separate times after I was compliant the first time. They kept on kicking me out of the house even though I wasn't even there.
Okay, so someone else is living there now?
I have no idea.
No idea. Okay. So you're not in possession and all right, that clears things up for me.
We're here for race judicata?
I believe so, because that
All
was,
right.
that was the basis that,
All right. I'm going to go real basic here. Intent plus the act equals a crime. The bank fills out all these paperworks, starts the foreclosure. They're moving, they're not doing the right things, they're perjuring themselves on stuff, but they're doing, that's the intent. The final act is when they push all the paperwork at Worcester of Deeds.
Sorry, I missed that.
The
They pushed
final
all
act-
the paperwork.
The
that-
final act of the
Couldn't hear it.
foreclosure is 2020. That's when, the point is when I can start to argue the foreclosure. I mean, if someone has intent to do something, I can't do anything. The intent plus the act equals the crime. What is the crime here? They foreclosed on 1.9774 acres of land, when in fact there's only 0.4963 acres of land. They're trying to steal property with a foreclosure. Everybody knows about Jim Roberti's title report. When you apply that to 45 Barry Road, there's just under a half acre of land. I can't start arguing this foreclosure until they pass papers at Worcester of Deeds, 2020. I argue the foreclosure, they say, oh, you already did that. No, I didn't. How can I argue something that hasn't been completed yet? All the attorneys say there's no foreclosure. It fell through, it failed. Craig Toohey said it failed. The bank pulled out because they couldn't get clear title. Because now, and for the record, the mortgage has never covered the septic system. And it doesn't cover the septic system today.
let me see if there are any further questions for you. All right, your time is up, so we're going to have to leave it there, and we're going to hear from the other side now.
But can I file a 16L letter?
Again, if you file a 16L letter, it needs to comply with Rule 16L, which is pretty limited. But you file it, and then we'll take a look at it and see if it complies.
Okay, thank you, Your Honor.
You're welcome.
Good afternoon, Your Honors.
What was the name of the lawyer that screwed this up?
I'm sorry?
What was the,
You're not allowed to speak at this point, Mr. Ryan. We're asking questions of Attorney Mechanic.
what was the name of the lawyer at the closing?
I'm sorry, I still didn't hear you.
Name of the lawyer at the closing?
At closing was Comey? George Corey.
Okay. And who did he represent?
He was an independent contractor hired by the bank to do a title examination.
To represent the bank?
Yes.
Okay. Did the bank give a disclosure that I've seen in almost every packet that I've ever been familiar with that said to the plaintiff here, Mr. Corey is not your lawyer. If you want a lawyer, you need to get a lawyer. Do we know if that was in the package?
We don't, and that's not part of the record before this court on the appeal. I don't recall, Your Honor. My firm did not have anything to do with that closing originally.
Okay.
Your Honor, one of the questions that was asked, I'm sorry, I didn't introduce myself, Scott Mechanic on behalf of GFA Federal Credit Union. Mr. Toohey, the purchaser's attorney, is Mr. Glennie. He's here, but he's not going to be arguing. So the answer is Mr. Glennie owns, or Mr. Toohey, Mr. Glennie's client, owns the property, and I believe they're living in it. So you were asked what was alleged, or what relief was, you asked what relief was sought. And at SA 32, which is a supplemental appendix, the Worcester Superior Court complaint is in there, and Mr. Ryan asked for, he had count 1, which was Chapter 93A, Section 2, Section 11, and he alleged at paragraph 26 on SA 32, the defendant willfully and or knowingly engaged in unfair and deceptive acts and or practices in violation of Mass General Laws, Chapter 93A, Section 2 and or Section 11, in its actions including, but not limited to, pursuing a foreclosure of a knowingly defective financing agreement having already sold the note and mortgage. So in count 1, he was contesting the bank's ability and authority to bring a foreclosure action. And the gavel had already gone down on the auction before that lawsuit was filed. So he knew that there was a foreclosure.
Your point is that he should also have contested the foreclosure at that time because it was part of the same nucleus of operative fact.
He did, because he brought the action for misrepresentation and violation of 93A based on the actions that the bank had taken with respect to the foreclosure proceeding. And in fact, as part of the summary judgment proceedings, and this is before the court at SA 62, there were statements of material fact, not in dispute, which is part of the Superior Court summary judgment procedures. One side sends a listing and asks that the other side admit it, or if they deny it, they have to give specific facts. Question 45, GFA Federal Credit Union entered into a master agreement and master commitment with the Federal Home Mortgage Corporation, Freddie Mac, on March 29, 2001. The terms and conditions set forth in the agreement apply to all notes sold by GFA to Freddie Mac. See, blah, blah, blah. The response was agreed. However, discovery has not been completed to verify same. If plaintiff were permitted under Rule 9A, he would neither admit nor deny it at this time. And there was a question about the promissory note. And there was a question about the endorsement of the promissory note to Freddie Mac. And there was a question about, at the time of the closing on the plaintiff's property, at all times since the closing, GFA has been the holder of the original mortgage and its service, and the servicer of the promissory note. So there are a series of questions from 45 through 51 that clearly address that not only was this known to Mr. Ryan, but as an affirmative defense to his claims of fraud, the bank was raising the issues of whether or not it had a right to do the foreclosure. Because if it did, as a holder, even if it didn't still own the note and mortgage, there was no causation. He wasn't harmed by the foreclosure. So that was explicitly litigated in the first Superior Court action. There are the pleadings in both cases.
What was the thrust of the motion for summary judgment with respect to his 93A claim? It's the statute of limitations, right? That's what the judge decided the case on.
Correct.
Okay.
But there was a footnote in Judge Mulkern's decision that said she would still grant summary judgment on the other claim, but she didn't have to because the statute of limitations question sort of trumped all. It was unnecessary for her to make those findings. And that same finding was in the appeals court decision.
How would the statute of limitations have barred a suit concerning the foreclosure itself? Like if there were some irregularity in how the foreclosure had been conducted, because that took place only a year before the filing of the Superior Court action.
I agree that perhaps Judge Mulkern made an error in that, but the case was appealed to the appeals court. And that issue was wide open for Mr. Ryan to say, appeals court, Judge Mulkern made a mistake. but he didn't raise the issue. He had the opportunity to raise the issue, and the whole case went to judgment. It's over. He had his shot. And just because he didn't know it, he didn't realize what it was he was mixed up in at that time, and I can understand that as a non-lawyer, but he's held to the standards of a lawyer. And a lawyer would have picked up that mistake by Judge Mulcairn if, in fact, it was.
Interesting to me that you haven't pointed out that you had a counterclaim.
Correct.
Quiet title.
Correct.
As to which you filed a motion for summary judgment.
Correct.
And as to which you succeeded. Why haven't you pointed that out? That seems to me to be a much quicker way to get to this.
I was addressing his points first to show why his points weren't well-founded.
Well, I thought maybe you left that out because when you actually moved for summary judgment, you only raised an issue about the rescission.
That is true, Your Honor.
You didn't specifically brief the question of whether your foreclosure was valid.
That's correct, Your Honor, and the reason for that is
But
it
somehow,
was pending.
when the judgment entered, it had a paragraph 3 that validated your foreclosure.
Correct.
I thought maybe you weren't pointing that out because of what I just pointed out.
No, I wasn't pointing that out because at the time, and it's not on the record, but we had a clouded title because of what he had done at the Registry of Deeds. And that was the specific thing that I was hired to take care of. And when we got that relief, we saw that Mr. Ryan's claim had raised the foreclosure issue and the failure to have the note and mortgage, which is the same thing he has been arguing all along. And we knew that it was going to be litigated by Attorney Connolly. So I took care of the problem that I was hired to take care of, and Mr. Connolly continued to litigate the issues that Mr. Ryan was raising, which included the status of the bank and whether or not they could foreclose on the property. So it was raised, and again, Mr. Ryan was concerned that the final judgment that the court entered, which was well after my motion for entry of separate and final judgment, if that was wrong, that was on the record at the time he filed his notice of appeal, and he filed his notice of appeal from that judgment, the final judgment that entered. So if there was a mistake, he had his opportunity. You don't get to keep taking bites and bites and bites out of the apple until you get the result you want. It's a claim that actually was raised, but it certainly should have been raised in the Worcester Superior Court action. And, the complaints in the land court case and the complaint in the Superior Court case track amazingly. There's a large number of paragraphs in both complaints that sound identical. And it shows that they were, in fact, at least on paper, litigated, whether or not Mr. Ryan realized they were being litigated, even though he's the one that filed both complaints. They parallel. And the extent of that parallel is what precludes this second action. As far as I can tell, Judge Smith made only one mistake, and that was he called Heacock. In his citation, it should have been Hancock versus Hancock, or Heacock versus Heacock. But everything else, his analysis of res judicata and issue preclusion and claim preclusion was spot on. Based on the record that was before him, his analysis was spot on. These claims at least should have been raised in the Worcester Superior Court action, a claim that went to appeal and upheld the decision of Worcester Superior Court. The claims in the land court action, as Judge Smith ruled, were correctly barred by res judicata. And if the court has additional questions, glad to hear them.
Any questions? No, I don't see any, so thank you Thank you both for your arguments, and with that, the case is submitted. We're now going to stand in recess for the day. Thank you to our court personnel, in particular Court Officer Spatty, for his help, and that's it for today.
All rise, please. Court is now in recess.